Hi, good morning everyone. In the last class we were discussing about the budgetary process in the parliament, and we have discussed that how the budget passes through the various stages, starting from the demand of grants that are put up by the various departments to the Ministry of Finance, then the preparation of the budget documents, then presentation of the same in the parliament by the finance minister, and then a general discussion takes place on the budget. And thereafter the budget enters into the committee stage, where the department related standing committees of the parliament prepare their detailed reports on the budgetary proposals, and thereafter the various cut motions are introduced on the demand of grants that have been put up by the departments, and once they are voted upon, the appropriation bill is introduced in the parliament. Once it is passed, then after that the finance bill or the provisions related to the taxation are introduced, and thereafter the budget stands approved or passed by the Parliament of India. So this is the entire procedure that we have discussed. We have discussed in this a few other aspects as well. What we have discussed is of vote on account as well. It is a tool through which the Parliament gives an approval to the executive to spend money according to the budgetary proposals till the time the budget is approved by the Parliament of India, because as we have discussed that not even a single penny can be spent out of the consolidated fund by the government unless there is an approval that has been provided by the parliament or by the legislature in case of the states. Now, let's say if during the functioning of the executive throughout the financial year, the parliament, the executive feels that if there was some particular money that had been allocated for a specific purpose, if it was found to be inadequate for that particular purpose, then in that case, what is the procedure that exists for the executive to be able to demand more money from the parliament? Or let us say that there is an uncontemplated service associated with an existing service. So let's say, for example, you have asked for the money for setting up of schools, but in the budget proposals, the executive had not exactly asked for some money to be provided for the smart classrooms to be set up in the schools. So if this kind of an added or a new expenditure comes up in the parliament, then for the executive, then how do they seek the approval of the parliament on this? So for this particular aspect, if you look at the provisions of Article 115 of the Constitution, we can get some clarity on that, right? So supplementary, additional or excess grants, these are some of the tools that are available to the parliament, according to which it can get the money if it has not been able to meet the requirements whichever mentioned in the budget for that particular year. So this is about the various grants that are made by the executive to the legislature, right? So the first one is what is called as supplementary grants. If you read in Article 115, Clause 1, Subclause A, the definition of supplementary grants has been provided. The President shall, if the amount authorized by any law made in accordance with provisions of Article 114, that is Appropriation Bill, to be expended for a particular service for the current financial year is found to be insufficient for the purposes of that particular year, or when a need has arisen during the current financial year for supplementary or additional expenditure upon some new service not contemplated in the annual financial statement of that year, caused to be laid before both the houses of the parliament another statement showing the estimated amount of that expenditure, or cause to be presented at the House of People a demand for such excesses as the case may be. So there are two kinds of grants that have been mentioned in Article 115, Clause 1, Subclause A. One is the supplementary grants and the other one is called as the additional grants. Supplementary grants is the first subcategory under Article 115, Clause 1, Subclause A, which is nothing but, it is mentioned under 115, Clause 1, Subclause A, when the funds allocated under the budget are found to be insufficient to meet the objectives during the current financial year. In such a case, the parliament may provide the executive with supplementary grant. So, for example, there was 500 crore rupees that had been asked for setting up of new police stations by the parliament from the by the executive from the parliament, and this approval was also given. अरे भाई तुम मतलब कहीं मिलते नहीं हो यार, तुम मैं घंटी भी बजाया, आ जाया करो ना एक बार. बड़ा यार मतलब मुश्किल है तुम लोगों को रीच आउट करना सुबह. सो आर्टिकल 115 क्लॉज 1 सब क्लॉज ए, 2 मिनट वेट करना अभी यहाँ पे. सो दिस वन इज टॉकिंग अबाउट सप्लीमेंट्री ग्रांट्स. ओके, नाउ इन दिस पर्टिकुलर केस, let's say 500 crore rupees had been allocated for setting up of police stations, and let's say during the financial year the government found that particular money to be inadequate, found that money to be insufficient, then they can ask for supplementary grant to be provided by the government, right, by the parliament. So 2 मिनट रुक जाओ, साइड में खड़े हो जाओ यार एकदम. So that is what is called as supplementary grant, you know. So say for example you go to a restaurant, right, and you have been given some money, let's say by your parents, you get selected in the exam, you had promised your friends that you would be taking them out for a dinner or lunch or whatever after you get selected, and then you asked your parents for this money. Your father has possibly given you 500 rupees and told you that you can go and have a feast. When I got selected in the exam, my father gave me 500 rupees. I had taken 10 of my friends and we had a gala time. So he gives you 500 rupees. Now you go to the restaurant there, you'll find that 500 rupees will not be sufficient to even feed one person. Forget about feeding 10 people, right? You may not be even able to feed them at a street food stall with 500 rupees if there are 10 people. So in that particular situation, what would you do? You would go back to the parliament, right, which is your father basically, and you would ask him to allocate you more money. And that is what is called as supplementary grant. तो उसी के लिए लिखा हुआ है cause to be laid before both the houses of the parliament another statement showing the estimated amount of that expenditure or cause to be presented to the house of people a demand for such excess as the case may be. तो अभी ये excess वाले केस पे आएंगे, बट ये पार्लियामेंट के सामने आपको सप्लीमेंट्री ग्रांट के लिए प्रपोजल रखना होता है. Then you please read article 115 clause 1 sub clause A का second part and related to the additional grants funds. Just give me a minute. Okay, so additional grants. They are granted when a need has arisen for an expenditure upon a new service associated with the existing service not contemplated in the budget for that particular year. तो उसको additional कहते हैं. देखिए ये thin line of differences है supplementary और additional के बीच में. Supplementary is that for that particular service only you have found the money to be insufficient, you are asking them for more money, right? Additional service के लिए associated with an existing service अगर आपको पैसा चाहिए, then you ask for what is called as additional grant. So you have taken your friends to, let's say, a restaurant. Your father has now given you 2,000 bucks. You take them to the restaurant and there they see a few other things also which are at display. They are sold in bottles. So, okay, I don't know. I don't know what you're thinking, but anyway, so there are a lot of things which are sold in bottles in the restaurants, right? So could be milkshake or could be a few other things which are consumed by people. So now in that case they want to consume that also. They want to have some milkshake also. So now they ask you that we want to have milkshake. So milkshake is not cheap. You see, I hope you understand which milkshake I am talking about. So it is not cheap. So now it is going to be additional expense that will be associated with the existing service, and you will ask for additional grants to be made to the executive by the parliament. So that is what is called as additional grants. Then there is third one which is called as excess grant. तो सप्लीमेंट्री और एडिशनल ग्रांट के लिए आप एक प्रपोजल बनाते हैं और आप उसको एक मनी बिल की तरह ही पार्लियामेंट के अंदर इंट्रोड्यूस करते हैं. लोकसभा में इंट्रोड्यूस होगा, and then Rajya Sabha also has a role to play, but only recommendatory role. ये सारे money bills होते हैं, because ultimately what are they doing? They are essentially trying to be, they are related to money matters. तीसरा जो है वो है excess grant. Okay, so excess grant is when you have already spent the money in excess of what was allocated to you by the parliament. Then you go back to the parliament and ask them to provide you extra money, and that is what is excess grant. So if you see, it says that if the money was found to be insufficient for the purposes, or when a need has arisen during the current financial year for supplementary or additional expenditure, ये तो हो गया 115 clause 1 sub clause A. Then if any money has been spent on any service, article 115 clause 1 sub clause B, during a financial year in excess of amount granted for that particular service for that year, then you will ask for excess money to be provided to you by the parliament. And for that, if you see, in it is written that cause to be presented to the House of People a demand for such excess as the case may be. So the excess grant demand has to be made in front of the House of People, and the House of People only approves it. Rajya Sabha doesn't approve it. Rajya Sabha does not have any role to play in case of excess grants, as it very clearly states. So the point which we need to understand is that excess grant is when you have already spent money in addition to what had been given to you, and then you go back to the executive, to the parliament, and ask them for money. So they are granted when the money has been spent on any service during the financial year over and above the amount granted for service in the budget for that year. Any excess grant must be approved by Parliamentary Accounts Committee before they are put to vote in front of the Parliament. And House of People, of course, is the house that has an upper hand in this. And Parliamentary Accounts Committee, we will talk about committees of the Parliament also. This particular committee is supposed to play an important role in ensuring the accountability of the government in the financial domain to the legislature. And that is where the excess grant comes in. So if you go to the restaurant, if you have already spent money in excess of the money that you have in your pocket, either you can fall in the feet of the restaurant manager and ask him to forgive you, or you can possibly go to the kitchen and wash a few utensils, and maybe he would let you go off. At least that's what they say. I have never done that, but they say ना कि मतलब अगर आपके पास पैसे नहीं है, आपने रेस्टोरेंट में खाना खा लिया, तो then you need to wash the utensils. What else would you do, right? Now, and in any other case, what would you do? You would have to call up your parents. You would have to ask them for excess money to be granted to you. So this is excess grant. तो ये तीसरे तरीके का है, जो स्पेशल तरीके का ग्रांट है, which is supposed to be made by the parliament to the executive. इसको कुछ थोड़ा बहुत नोट कर लीजिएगा. मेरे को आप देखिए, क्लास में अगर आप सिर्फ केवल इसको देखते रहेंगे, आप घर पे जाके तो इसको नोट करने नहीं वाले, है ना? तो अभी कम से कम कुछ थोड़ा बहुत लिख लीजिए, so that you have some recollection and memory of that fact you have studied this. वैसे भी आधी चीजें आपको भूल चुकी हैं ऑलरेडी, जो पढ़ाया गया है पहले का, है ना? ये सच्चाई है आप में से सबके लिए, मैक्सिमम के लिए यही सच्चाई है, बिकॉज यू डोंट रिवाइज रेगुलरली. तो आप कम से कम क्लास में आ रहे हैं तो कोशिश कीजिए यू यूज योर टाइम प्रॉपरली. क्लास में केवल यहाँ पे बैठने के लिए मत आइएगा, प्लीज, इज व्हाट आई वुड सजेस्ट. यू शुड ट्राई टू ensure that you are reducing the time that you are actually spending on a topic by attending the class. So now the other is then exceptional grants. So what is exceptional grant? They are granted to make an expenditure on a service that is not a part of any service in the current financial year. So if additional grant was for additional expense on any particular service associated with the existing service, supplementary grant was for money to be spent extra on a particular service, excess grant was when you have already spent the money. This one is different. A service that was not a part of service in the current financial year, ये एक exceptional service है. So let's say there is some money which has been asked by the executive from the parliament in the budget for healthcare sector, but it turns out that some new epidemic, some new pandemic has hit us, and we need to develop a new vaccine for that. Let's say what we witnessed during COVID. Now government needs some extra money for developing the vaccine. This was not something which had been contemplated in the budget of that particular year. In that case, you would ask for an exceptional grant be made to you by the parliament. So you can also read the article 116 of the Indian Constitution, where the provisions related to exceptional grants have been mentioned. 116 clause 1 subclause C. Notwithstanding anything in the foregoing provisions of this chapter, the House of People shall have powers to make an exceptional grant which forms no part of the current service of any financial year. So that is what we need to keep in mind, and Parliament shall have power to authorize by law withdrawal of money from concerned fund of India for the purpose of which the said grants have been made. So I hope you understand what is exceptional grant. Okay, this was not contemplated only earlier. So this is exceptional grant. Then the last one is what is called as vote of credit. So vote of credit has been mentioned in Article 116 clause 1 subclause B. Notwithstanding anything in the foregoing provisions of this chapter, the House of People shall have the powers to make a grant for meeting an unexpected demand upon the resources of India, when on the account of the magnitude or indefinite character of the service, the demand cannot be stated with details ordinarily given in an annual financial statement. So there is an exceptional service that has arisen, and because the magnitude or the character of the service is so indefinite in nature, you can't in ordinary terms state that on the budget proposals, or you can't state that in a particular statement. What you do in that case is, you go to the parliament and ask them to give you a blank check. You spend the money, and then later on you come and tell the parliament that this is the amount of money which has been spent. This is what is called as the vote of credit. अब इसका मतलब क्या है? Suppose कीजिएगा कि again, similar kind of situation, COVID-19 has occurred. Government has to take some extraordinary measures in order to improve the healthcare facilities during that particular financial year. But government doesn't know exactly how much amount of money will be required for that purpose. They do not even know the character of the service as well. Maybe let's say it's a war that has happened. अब government को नहीं पता कि war के लिए कितना पैसा लगेगा. They can't state it right away. In that case, they will go to the parliament, ask them for vote of credit, which is nothing but you give us a blank check to spend money as and when the requirement will arise. And once we have spent the money, we will come back to you and we will present the expenditure in front of you and take your post approval at that point of time. This is what is called as vote of credit. So that's why it is granted for meeting an unexpected exceptional demand on the resources of India, when on the account of the magnitude or indefinite character of the service, a demand for grant has arisen that cannot ordinarily be stated with details given in the annual financial statement. It is like a blank check given by the parliament to the executive. Please understand the difference between exceptional grant and vote of credit. Both are happening in exceptional situations, but in vote of credit, you do not even know how much money would be spent. You do not even know exactly the character of the service that would be provided by the government and the money that would be required for that purpose. In exceptional grant, you at least know कि कितना पैसा खर्च होगा, आप किस सर्विस के लिए पैसा मांग रहे हैं गवर्नमेंट से. So that is what is from the parliament. So exceptional grant और vote of credit में वो फर्क है. That is what you need to keep in mind. I hope that this is clear to all of you, right? So this is as far as the vote of credit is concerned. We have also discussed about vote of account as well, vote on account as well, which has been mentioned in Article 116 clause 1 subclause A. Notwithstanding anything in the foregoing provisions of this chapter, the House of People shall have powers to make any grant in advance in respect of the estimated expenditure for a part of any financial year, pending the completion of the procedure prescribed in Article 113. For the voting of such grant and the passing of the law in accordance with the provisions of Article 114 in relation to that expenditure. I hope you understand that. तो वो कह रहा है pending the completion of the procedure provided in Article 113, जिसमें कि procedure in Parliament with respect to estimates mentioned है. जब तक ये procedure ना complete हो तब तक ये थोड़ी ना है कि government नहीं चलेगी, जो हमने बात किया था. And that is why vote on account is used by the government as a tool to seek approval from the Parliament on spending the money as per the budgetary proposals, right? So these are the various type of exceptional grants or exceptional ways in which you can ask for money in excess of what has already been given to you by the Parliament of India during the current financial year, right? अब इसमें एक और चीज जो हमें डिस्कस करना था in the budgetary proposals, which is this. Also you should read and you should cover the aspect which I had told you, जो question हमने देखा था last class में, इसी slides के अंदर beginning में है, that how the budget process in India has weakened, how the accountability of the executive to the Parliament of India has weakened, and how there are certain loopholes in the way the budget gets approved in India, and how those things can be improved. For example, if you people know, almost 97% of the budget in the last decade or so in India has been approved by the Parliament without any discussion. So बजट के ऊपर डिस्कशन होता ही बहुत कम है. तो अब आप सोच के देखिएगा, इतने बड़े बजट के अंदर, लाखों करोड़ों के बजट के अंदर, in the government is able to spend the money even without discussion from the Parliament of India. If you had read the news of last year's budget, इस बार का तो खैर इंटरिम बजट है, but if last year's budget, if you had read the news, almost some 2 lakh crore rupees had been approved by the Parliament of India within a discussion of half an hour. So that clearly shows that the control of the Parliament on the executive in the financial or in the budgetary matters is declining, because there is hardly any discussion that is taking place in the Parliament on the budgetary proposals. And this is essentially creating a lot of scope of misuse of the provisions of the Constitution, as well as misappropriation of funds, misutilization of funds. So a number of other these things are also happening. So वो आप पढ़ लीजिएगा. Anyway, now this is another important thing, right? This is, even though it's very obvious, why does the Parliament of India does not discuss the demand of grants in detail by itself? Why is this function delegated to the parliamentary committees, which is the department related standing committees of the Parliament? Why are they given this particular duty or this particular responsibility? So a few reasons I have mentioned here. First reason, of course, being that the Parliament consists of layman politicians. These are people, those who do not necessarily have any background in economics, in accounting, in finance, and therefore it is very difficult for them to actually ask tough questions of the government on the budgetary proposals that they have submitted. And that is where the department related standing committees come in. Why? It's not that department related standing committees would not have members of the Parliament or you would get someone from outside, but department related standing committees can be formed in such a manner that there is some expertise that exists within those committees. What I mean to say is that in the department related standing committee to health, you can have a few doctors or people, those who have had experience of the medical field as a part of it, and it will be easier for them to ask questions and to hold the government accountable on the demand of grant that has been made by the Ministry of Health. Similarly, in the department related standing committee on, let's say, home affairs, you could have possibly a few members of the Parliament, those who have had experience with respect to home affairs. They may have been ministers of home affairs either in the previous union governments, or they may have been ministers of home affairs in the states, or they may be former IPS officers, or anyone who may have special knowledge of the home affairs aspects, and therefore they may be able to actually understand that whether the demands that have been made by the Ministry of Home Affairs are legitimate or not, or are they asking for extra money which is actually not justified. So that is one reason because of which the role of the parliamentary committee becomes very important, because usually the parliament consists of laymen, but in department related standing committees you can have some expertise at least. Also, department related standing committees can always invite for the outside experts also to make some representations or to appear in front of the committee, whose aid or whose help can be sought by the committee. Not so much in case of the Parliament of India. So एक तो ये advantage है. दूसरा reason ये भी है, the Parliament is too big a group of people to take any effective decision on such complicated matters. So you cannot expect a 540 member Lok Sabha to be looking effectively into the budget proposals, because it will be too difficult to do that. To have any kind of a cogent discussion between such a large group is very difficult. And that is where the parliamentary committees come in. Why? Because again, these are smaller groups. So the discussions that happen in these particular committees would be way more focused, and they would be way more detailed as well. And therefore, ensuring the accountability of the executive would become much easier in such cases. Third is that the task can be best performed by committees that are relatively smaller, and therefore they are more effective. And fourthly, the functioning of the committees is relatively apolitical, as the discussions happen behind the closed doors. So this is another important aspect. We will discuss about parliamentary committees also, and at that point of time also I will discuss with you that how parliamentary committees are so crucial, are so important, है ना. तो उसके अंदर एक बड़ा रीजन ये भी है, क्योंकि जब पार्लियामेंट के अंदर डिस्कशन होता है वो टेलीवाइज डिबेट्स हो रही हैं. You can't say things which may hurt your political interests. You may not want to praise the government if you are in the opposition. You may not want to praise the opposition if you are in the government. Or you may only want to praise the government when you are when you are from the ruling party in the parliament. But क्योंकि parliamentary committees की discussion closed doors में होती हैं, in camera proceedings कहते हैं हम उसको. In that particular case, you can always criticize the government policy as well. You may be from the ruling party. You can always support the government as well. You may be from the opposition party. Why? Because no one outside is going to know what exactly was the discussion that happened in the parliamentary committee. As a result of that, usually people tend to let go of their political interests and focus more on national interest in the functioning of the parliamentary committees. Right? So this is also another aspect of the functioning of or the budget aspects that we need to keep in mind in India. So this is what you need to know. So इसके अंदर अब देखिए, now I doubt if UPSC will ask you a mains question where they will ask you to explain the budgetary proposals or budgetary process in India, but still you should have a broad idea of what to write in the exam, you know? And prelims examination, many questions have been asked from this particular topic in the past, and you should know, as we have discussed, the thin line of difference between the exceptional grants and vote of credit, and between supplementary grants and additional grants and excess grants. बहुत easy है ना. इसके अंदर बस वही याद रखिएगा कि supplementary is to supplement something that exists. Additional is to add something to what exists. Excess is when you have already spent something in excess. Vote of credit, you are taking a credit from the parliament and asking them that let me spend money, I will come back to you after a few days. And exceptional, when an exceptional situation has arisen, but not like vote of credit, because vote of credit may, you can't even state in ordinary terms what exactly is the expenditure that has been made, which has to be made, and the category of expenditure, etc. related to those things. I hope that this is understood to all of you, right? Parliamentary budget proposals and budget process. Now let's move on to the next topic, and which one is related to parliamentary privileges, okay? Parliamentary immunities and privileges in India. So the concept of parliamentary privileges and immunities comes from Britain. The concept essentially is that the parliament should be able to function in a free and a fair manner without any kind of pressure being exerted on them by the executive, without any kind of pressure being exerted by the judiciary or by any other external force. Any parliamentarian should be able to speak out their mind in the parliament on the policies of the government without any kind of fear in their mind. It should not be, let's say that if there is a particular parliamentarian who's making a speech in the parliament is threatened by the executive that if you make such a speech, we will file a defamation case against you. If you make so and so speech, then in that case, we will be charging you with some sedition law or something like that. So that should not be the case. That is why these parliamentary immunities and privileges have been provided to the parliamentarians in India. So these are special protections given to the legislators in India, both to members of the parliament as well as members of state legislatures, so that they can carry out the functions and the duties associated with their office in an impartial manner, without any kind of fear in their mind, without any kind of inhibition in their mind, right? So let's discuss what these parliamentary privileges are. Again, I am not going to be dictating notes related to this topic. The handout is there and that is what we will be using. Please write down. Parliamentary immunities and privileges refer to special rights enjoyed by Parliament as an institution, enjoyed by the Parliament as an institution, and the parliamentarians in their individual capacity. Without such special rights, they cannot discharge their functions. Given to them. They cannot discharge their functions given to them by the Constitution. Right. So now, for parliamentary immunities and privileges, we can have a look at the provisions of Article 105 of the Constitution. Right. This one says powers, privileges, etc. of houses of the Parliament and of members and committees thereof. Firstly, if you see Article 105 Clause 1, it says that subject to provisions of the Constitution and to the rules and the standing orders regulating the procedure of the Parliament, there shall be freedom of speech in the Parliament. So, one parliamentary privilege that is given to the parliamentarians is that they have freedom of speech and expression in the Parliament. According to Article 105 Clause 2, a member of the Parliament cannot be held liable to any proceedings in a court in respect of anything said or any vote given by him in the Parliament or any committee thereof. And no person shall be so liable in respect of publication by or under the authority of either House of Parliament of any report, paper, votes or proceedings. तो अगर हम parliamentary proceedings के बारे में बात करें, parliamentary privileges या parliamentary immunities के बारे में, one source of these parliamentary immunities or privileges is the Constitution of India. According to which, as we have seen, if as a parliamentarian you say or do something in the Parliament, you cannot be held legally liable for it outside the Parliament. Recently, a MP from Delhi made some unsavory remarks, possibly even ones which could have been called as hate speech under section 295A and 153A of the Indian Penal Code in the Parliament. But no FIR was filed against him. The reason being, they enjoy parliamentary privileges within the four walls of the Parliament. Outside the Parliament, had he made such speech or had he made such comments, he would have definitely been charged with provisions under 153A and 295A. But he got away from all of it because he was under the privilege of the Parliament, under Article 105 Clause 2, as we have read, कि आपके पास complete freedom of speech है Parliament के अंदर, and you cannot be held liable in respect of any vote given or in respect of anything that you have said in the Parliament. So firstly, the parliamentary privilege that is enjoyed by the parliamentarians can be drawn from the Constitution of India itself, right? Freedom of speech, and we can say that this freedom of speech is being drawn from the Constitution. Now, other than this particular parliamentary privileges, there are other privileges also enjoyed by the Parliament or by the parliamentarians. But what we need to know is that Constitution explicitly doesn't mention what these privileges are. It has given the responsibility to the Parliament itself in India to make a law and to define its privileges. Some of these privileges have been mentioned in some specific laws made by the Parliament of India separately for some other purpose, but उसमें कुछ privileges भी included हैं. Some of these privileges are more a matter of convention. So for example, if you read the provisions of CPC 1908, in that, in a civil case, an arrest cannot be made of a parliamentarian during before 40 days and after 40 days while the session of the Parliament is going on. So what that means is that, let's say if the parliamentary session is going on right now, either during this parliamentary session, 40 days before the parliamentary session and 40 days after the parliamentary session, no arrest can be made in a civil case against a parliamentarian or against a legislator also, because 105 का corresponding provision 194 में भी mentioned है. Anyway, this particular privilege or this particular immunity is enjoyed by the parliamentarians because of not the Constitution but because of the Civil Procedure Code that gives them this protection. ठीक है, तो ये दूसरा privilege है parliamentarians का, no arrest in a civil case 40 days before, 40 days after or during the ongoing session of the Parliament. Plus, of course, they have the second privilege, which is the freedom of speech and expression within the Parliament, which is derived from the Constitution itself. So ये दो privileges हो गई. Then, apart from that, a lot of other privileges are drawn by the conventions. So convention से draw किया जाता है privileges. अब British convention से ये privileges कहां से आता है? Let us try to understand that. ये ब्रिटेन की convention से आ रहा है. Article 105 Clause 3 has been amended by the 44th Constitutional Amendment Act. The original provision of 105 Clause 3 read as follows. In other respects, that is other than 105 Clause 1 and 105 Clause 2, the powers, privileges and immunities of each House of Parliament and the members of the committees of each House shall be such as may from time to time be defined by Parliament by law. तो ये Parliament by law define करेगी and until so defined. इसके बाद का टेक्स्ट ये था, and until so defined shall be the same as that of House of Commons in Britain. So originally the Constitution stated that कि जब तक Parliament अपनी खुद की privileges और immunities define नहीं करेगी law बनाकर, they will be same as that of the House of Commons in Britain. But when the Janata Party government came into power, they stated that we have an objection with this. How can they in the constitution be mentioning that the privileges and the immunities of the Indian parliamentarians shall be same as that of House of Commons? Why are we dependent on the conventions of our colonizers in our constitution? तो इसको delete किया जाए. और फिर उन्होंने ये include कर दिया that until they have been defined in the law made by the parliament, they shall be of those of that house and of its members and committees immediately before the coming into force of the 44th Constitutional Amendment Act. So जब तक Parliament 44th Constitutional, जब तक Parliament खुद से privileges define नहीं करती है, they will remain to be the same as that of what they were before 44th Constitutional Amendment Act came into force. 44th Constitutional Amendment Act force में आने से पहले उनकी privileges क्या थी? That of House of Commons. तो जब तक पार्लियामेंट लॉ नहीं बनाएगी तब तक ये हाउस ऑफ कॉमन्स वाली ही प्रिविलेजेस रहेंगी, है ना? तो आपने बेसिकली कुछ चेंज नहीं किया है कॉन्स्टिट्यूशन में, आपने बस हाउस ऑफ कॉमन्स का प्रोविजन डिलीट कर दिया है. दिस वन कुड से इज अ हिपोक्रिटिकल मूव ऑल्सो बिकॉज पार्लियामेंट सिंस देन हैज नॉट इनैक्टेड एनी लॉ टू डिफाइन इट्स privileges and immunities. So what are the privileges and immunities of the parliament according to article 105 clause 3 at present? Same as House of Commons, because they have not made any law. Do you understand what I am trying to say? ये बात समझ में आ गई है सबके, right? कि it was same as that of House of Commons before the 44th Constitutional Amendment Act came into place. 44 से आपने बोला नहीं नहीं, it will be same as that it existed before 44 came in till the time the parliament enacts a law. But parliament ने आज तक कोई law ही नहीं enact करी है, and as a result of that we have not been able to define the parliamentary privileges comprehensively and we rely upon British conventions. तो अब ब्रिटेन में क्या कन्वेंशंस हैं जो कि पार्लियामेंट को प्रिविलेजेस देती हैं इंडिया में, राइट? सो वन वी हैव डिस्कस्ड freedom of speech derived from constitution, freedom of arrest in civil cases derived from CPC, and then there are other privileges that are derived from the privileges of House of Commons, which are more in a convention sense in Britain as well. One, for example, is that a parliamentarian cannot be arrested, cannot be made a witness in a case 40 days during, 40 days before, 40 days after, and during a session of the parliament. You have exclusion from the being appearing as a witness in front of the parliament. So this is what has been mentioned, that there is an exemption from attendance as witness, right? In any case during the session 40 days before and 40 days after as well. तो ये कहां से आ गया? ये कन्वेंशन से आ गया, ब्रिटेन की 105 क्लॉज 3 की रीडिंग से. तो ये तो कुछ इंडिविजुअल प्रिविलेजेस हुई पार्लियामेंटेरियंस की. देन देयर आर कलेक्टिव प्रिविलेजेस आल्सो दैट आर एंजॉयड बाय द पार्लियामेंटेरियंस, अगेन डिपेंडेंट ऑन द कन्वेंशंस ऑफ ब्रिटिश हाउस ऑफ कॉमन्स इनकॉर्पोरेटेड इनटू इंडिया बाय द वर्च्यू ऑफ 1053. सो व्हाट इज दैट? कलेक्टिव प्रिविलेजेस that the parliament has right to punish a person or a group, either an outsider or a member of the parliament, for the breach of privilege of the parliament. If there is a member of the parliament also who breaches or violates any of the privilege of the parliament, then in that case parliament can punish them. One of the privilege of the, another privilege of the parliament collectively that is drawn from the British House of Commons is that the parliament has exclusive rights and powers to publish the proceedings of the parliament. If anyone has to publish the proceedings of the parliament, they must have permission from the parliament to be able to do so. Another important thing is that if, let us say, you have been given permission by the parliament to publish the proceedings of the parliament, and what you have published, you are held there is some criminal case that is filed against you, you cannot be held legally liable for the same. What I mean to say is, this particular parliamentarian made some hate speech in the parliament. He cannot be held legally liable for it because of protection under article 1052. But let us say, अगर आप उस स्पीच की क्लिपिंग को निकाल के सोशल मीडिया पे डालते हैं, अगर आपके पास पार्लियामेंट की परमिशन है ये करने की, तो आपकी भी कोई लीगल लायबिलिटी नहीं है. पर अगर आपको पार्लियामेंट की परमिशन नहीं है, तो फिर आप लीगल इम्यूनिटी एंजॉय नहीं करते हैं, और उस केस में आपके खिलाफ लीगल प्रोसीडिंग भी हो सकता है. मतलब आपके खिलाफ हो सकता है कोई केस ऑफ हेट स्पीच फाइल कर दे अंडर section 295A or 153A of the IPC. Why am I saying that? Because in 105 clause 2, it says that, and no person shall be so liable in respect of the publication by or under the authority of either house of parliament of any report, paper, votes or proceedings. ये बात समझ में आ रही है? मतलब कि अगर एज अ मेंबर ऑफ द पार्लियामेंट मैं कोई स्पीच देता हूं पार्लियामेंट के अंदर, और अगर उसको पब्लिश कर दिया जाता है एज पर द अथॉरिटी ऑफ द पार्लियामेंट, देन दैट publishing house will not be held legally liable for the same as well. But if you don't do it without the permission of the parliament, then of course you can be held legally liable. It also means that if I go ahead and publish the proceedings of the parliament without the permission of the parliament, then also I can be punished by the parliament. Why? For breaching their privilege. It is the privilege of the Parliament of India to publish their proceedings and debates. कोई और नहीं कर सकता. अगर कोई और करता है without permission of the parliament, that person can be held guilty of breach of privilege of the parliament. Is that understood to everyone? Now, another privilege of the parliament is associated with this only. If parliament alone has the right to publish the proceedings of the parliament, they can even ask the strangers to be excluded from the proceedings of the parliament. In parliament, there are two galleries which are there, in which people from the press and visitors can come and see the proceedings of the parliament. जो प्रेस गैलरी है उसमें प्रेस के मेंबर आते हैं, और विजिटर्स गैलरी में normal visitors can come in. Of course, you need prior permission and passes, etc., and all of that to attend the proceedings of the parliament. So this recent attack that took place in the parliament, breach of security, was nothing but basically people, those who had entered the house from the visitors gallery only. So if the parliament wants, it can even conduct the proceedings behind the closed doors and shut down the visitors and the press gallery. During COVID-19, because there was a danger that the virus may spread further, the parliament shut down its press and its visitors gallery, and because they have the right to do so, they have the privilege to do so. So another privilege is, each house of the parliament also enjoys the right to exclude the press and the strangers from witnessing the proceedings of the parliament. Is that understood to everyone? Now, from 105 clause 2 and the understanding that we have built is that a parliamentarian cannot be held legally liable outside the parliament for anything said or anything done in the parliament. Question is, does that mean that the parliamentarians have absolute freedom of speech and expression in the parliament? They can do anything and everything in the parliament. The answer, of course, is no. So the limitations are put on the freedom of speech and expression of the parliamentarians within the parliament by the rules and the procedures of the parliament. So if you do or say some things in the parliament which are unparliamentary or violating the rules and procedures of the parliament, you can be punished by the parliament itself. In some cases, you may be asked to withdraw from the house by the presiding officer of the house. So the presiding officer may give a direction to a member of the house who's acting as unruly or who is not willing to follow the basic rules and guidelines of the parliament to withdraw from the house. Second is that in some more grave situation, a parliamentarian may be suspended also from the house. For that, the presiding officer would have to introduce a motion of suspension naming the MP, and if the motion is adopted by the house, that is, it is voted upon by the house, then in that case the MP shall be suspended from the house. There is a third way also in which an MP may be expelled from the house as well, where a particular committee of the parliament may suggest expulsion of an MP for violating the privilege of the parliament, or it may be an action that may be suggested by the presiding officer as well. The house then votes upon that particular motion for expulsion of that MP. If it is voted upon, agreed upon, then that MP can be even expelled from the parliament as well. So the point which we need to keep in mind is that you don't have absolute freedom of speech and expression in the parliament. Okay, and for breaching the privilege of the parliament, even a parliamentarian can be punished by the parliament. For example, a few years back, the present Chief Minister of Punjab, when he was a member of the Lok Sabha, he happened to do a Facebook Live on his Facebook account, and he showed that when he left from his house till entering into the gates of the parliament, then going through the security and then entering into the parliament, he showed all of it live on his Facebook. Some people objected to this in front of the Speaker of the Lok Sabha, stating that, ma'am, this is actually going to create a problem because this can lead to breach of security in the parliament, because he has shown the entire procedure of how the security etc. happens. So he has breached the privilege of the parliament by showing the proceedings of the parliament without the permission of the parliament, and therefore he should be punished for the same. And as a result of that, he was suspended from the parliament for a few days, because there was a motion that was introduced by the presiding officer in the house, which had been adopted by the majority of the members of the Lok Sabha present and voting on that particular day. I hope that this is understood, है ना? तो एक ये चीज है. अच्छा, सपोज कीजिएगा, अब ये एक केस आ चुका है कि some of the parliamentarians were found guilty of taking money and then voting in the house, or some of the parliamentarians were found guilty of taking money, taking bribe and asking questions in the house. तो इसके ऊपर एक sting operation किया गया, and that is how it was found out. So now the question is that can these people be held legally liable in the court for this particular thing? Because क्या ये तो offense of bribery है ना? What is bribery according to according to Prevention of Corruption Act? When you take some consideration, some gratification in return for performing some official duty associated with your office. एक parliamentarian की official duty में क्या आता है? To ask questions in the parliament. अगर वो questions पूछने के लिए पैसे ले रहा है तो ये bribery है, and therefore it should be termed as a corrupt activity under Prevention of Corruption Act. तो क्वेश्चन ये था कि क्या इन लोगों के ऊपर प्रिवेंशन ऑफ करप्शन एक्ट के अंदर एफआईआर फाइल की जा सकती है कि नहीं. सुप्रीम कोर्ट ऑफ इंडिया हैज स्टेटेड दैट the parliamentarians, because they enjoy privilege and immunity because of Article 105 Clause 2, cannot be charged with the offense of bribery or under any ordinary law outside the parliament, because it would then be breaching the provisions of the constitution. And if anything has to be done, that has to be done by the parliament only. So therefore, in 2005, when some of these members of the parliament were found to be taking cash in return for questions that they would ask in the parliament, they were expelled by the then presiding officer of the Lok Sabha. So a motion was introduced in the house related to the expulsion of these members of the parliament. It was voted upon by a majority of the members of the house, and as a result of that, these members were expelled from the house as well.
तो इसका मतलब यह है कि सुप्रीम कोर्ट की अभी तक का ओपिनियन तो यह कहता है that for what you do and you say in the parliament, you can't be held legally liable outside the parliament, but you can be punished by the house. But let me also tell you, Supreme Court is now in the stage of reconsidering its earlier decision on this particular matter, which had come up in the court in the PV Narasimha Rao case, which was this case only, where some of the members of the parliament were found to be taking money in order to vote against the government in the Lok Sabha, in the no confidence motion. तो इसके ऊपर अभी सुप्रीम कोर्ट फिर से अपना हो सकता है डिसीजन रिकंसिडर करके कुछ डिफरेंट ओपिनियन दे दे, बिकॉज दिस इज ऑफ कोर्स वेरी डेंजरस, यू सी, बिकॉज यू आर टेकिंग मनी फॉर आस्किंग क्वेश्चंस और फॉर वोटिंग इन दी पार्लियामेंट, एंड आपको इसके लिए लीगली लायबल भी नहीं होल्ड किया जा रहा है, तो आपके ऊपर डर क्या है? फिर एक ही डर है बस आपको कि मुझे पार्लियामेंट से एक्सपेल कर दिया जाएगा। बट अगर आप रूलिंग पार्टी के मेंबर हैं तो क्या आपको एक्सपेल किया जाएगा? नो। सो दिस विल ऑल्सो देन फॉल अपॉन द ऑपोजिशन मेंबर्स ओनली। सो दिस इज अ डेंजरस और वन कुड से पॉसिबली अ रिस्की judgment that has been given by the court, and therefore we hope that the court will give a judgment which will reverse its earlier judgment. I hope this is understood. So if we talk about breach of privilege in the parliament or breach of privilege of the parliament, what happens in that particular case? So the parliament has the powers to punish those individuals who are guilty of breaching the privileges of the parliament. So if any parliamentarian or outsider is guilty of breaching the privilege of the parliament, they may be punished by the parliament, including imprisonment as well. Usually what the parliament does, if it feels that a privilege of the parliament has been violated, they issue a show cause notice to that person. If after that show cause notice has been issued, the concerned parliamentarian or the legislator cannot provide a logical and a coherent explanation, they may be punished by the house as well, or they may be punished by the parliament as well. For example, when the Ram Leela ground agitation, this entire India against corruption agitation was taking place in Delhi, two people were held to be guilty of breach of the privilege of the parliament. One was Mrs. Kiran Bedi and the other one was Mr. Om Puri. Both of them on the stage in the Ram Leela Maidan had made some comments which did not go down well with the parliament. Om Puri, so that's why they felt very hurt. Right? Now, of course, this is an over exaggerated statement that all of them are choro chakka, but see, the fact is that the record itself suggests facts don't lie, numbers don't lie. Numbers say that even in the 17th Lok Sabha, more than 30% of the MPs were charged with serious offences. They were charge sheeted with serious and heinous crimes such as sexual assault, rape, dacoity, robbery, etc. And I always say this, that the blame should not go to the parliamentarians for this. The blame should go to the people of this country. If you are electing them to the parliament, that means that you want them to be there in the parliament. You actually are choosing criminals to go to the parliament. You want such people in the parliament. It is your choice. You always had a choice to choose clean candidates also, but you don't want to choose clean candidates. You want gundas to go to the parliament. So you are electing them. Of course, this goes without saying that many other, see, 30% ही है ना, 70% may be having clean record. Many of them may actually be very honest. Many of them are actually very honest and very hardworking parliamentarians as well. But there is a small percentage of them that brings bad name to the parliament. Anyway, whatever the case. So they made some comments. Parliament को लगा कि ये तो हमारी contempt है, ये हमारी disrespect है. And that is where the parliament issued show cause notice to these people. कि आप बताइए कि आपने ये क्यों बोला, और अगर आप explanation नहीं देंगे, then we will take action against you and even punish you for the breach of the privilege of the parliament. So what did these guys do? They tendered unconditional apology to the parliament and they said that we are really sorry, our intention was not to disrespect the parliament, we were just wanting to express our concern. but we will not repeat this in future. Now this has raised questions. ऐसे और भी बहुत सारे instances हुए हैं कि किसी एक particular आदमी ने editorial लिख दिया जिसमें उन्होंने जो चेयरमैन ऑफ राज्यसभा थे उनके बारे में या डेप्यूटी चेयरमैन के बारे में कुछ बातें लिख दी. The presiding officer of the Rajya Sabha was referred to as a coward in a newspaper. तो उस न्यूज़पेपर के एडिटर को ब्रीच ऑफ प्रिविलेज के लिए गिल्टी पाया गया. बट देन द पार्लियामेंट सजेस्टेड नॉट टू टेक एनी एक्शन अगेंस्ट हिम बिकॉज पार्लियामेंट पॉइंट ऑफ व्यू वाज कि possibly this person made these comments in order to get publicity. Possibly this person made these comments just out of the blue. We should not punish people for such inane acts that they are committing. By involving ourselves in punishing such a person, we are only giving more importance to that person. You remember the contempt of court discussion that we had? When the court is unnecessarily giving a lot of importance to remarks made by some people, it is not really elevating the image of the court. In fact, लोग यही सोचेंगे कि कोर्ट तो इतना बड़ा इंस्टीट्यूशन है, उसको ये सब ओवरलुक कर देना चाहिए, right? So that is what we need to keep in mind. So one of the stories, for example, goes around saying that there was one guy who used to see, this may be a story only, folklore only, I don't know how true that is, but one guy used to write letters to Gandhi, and he used to write the choicest of the abuses in these letters that he would send to Gandhi. So what would Gandhi do? He would receive these letters, and on the top of these letters there would always be a paperclip or a pin. So he would take out that paperclip or that pin and he would keep it with himself, and he would throw away those letters. So he thought that anyway these letters are of no use to me, let me see that what can be of use to me in these letters, and possibly I can use this paper as a toilet paper or I can possibly be using this, whatever. I'm just telling you that if you are in a higher position and if someone makes some kind of unsavory comments or remarks against you, you should not react so much, because there will always be people who will criticize you, right? If the Prime Minister of the country was to open up his Instagram or Twitter account or whatever, I don't know, or to go on social media what people are saying about him every day, then he would be in depression the next day. Do you understand that? He cannot function in that office. When you people would be in government offices, आप लोगों को भी बहुत सारी गालियां पड़ेंगी, ये बात याद रखिएगा, है ना? जो क्रिकेटर्स हैं, बॉलीवुड सेलिब्रिटीज हैं, इन्फ्लुएंसर्स हैं, उनको बहुत गालियां पड़ती हैं. लोग नीचे आके कुछ भी लिखते हैं उनके बारे में. डू यू थिंक दैट दे रिएक्ट टू इट? If they would start thinking so much about it, Virat Kohli was to open up his social media account and see the kind of comments people write below it, then he would stop playing cricket the next day, because he would realize that some Bablu from Karol Bagh has written on his Twitter account कि भाई ये तू कैसे शॉट खेल रहा है, मैं तेरे को सिखाता हूं. You getting what I am trying to say? So you should ignore it. So that is what happened. But the problem is that because privileges of the parliament are not defined in any law, parliament can bring up in any case and say that our privilege has been breached, and they can therefore punish an individual for the breach of the privilege of the parliament. अब ये बड़ा डेंजरस है, क्योंकि जब आपने डिफाइन नहीं किया हुआ है तो ये बड़ा आर्बिट्ररी है, and if it is arbitrary, it can lead to misuse as well by the parliament, and that is what we need to keep in mind. So the parliament may punish an individual who is guilty of breaching the privilege of the house. Such a breach may be committed by the members of the house or by the outsiders as well. When an MP is involved in misbehavior or commits contempt of house, he or she may be expelled from the house as well. For example, in 2006, 11 members were expelled by the Speaker of the Lok Sabha in cash for question scam. This we have discussed. Then apart from it, what is the punishment? The house can ensure attendance of the offending person and ask him to explain what comments were made by him or what act was done by him that led to the breach of the privilege of the parliament, and the person can be given a warning and let go, or may even be sent to the prison as well. For example, there was a case in which some of the people from the visitors gallery had thrown chappals and leaflets in the house. In that case, they were sentenced to simple imprisonment by the house. In 2008, an editor of a Urdu news weekly, referred to the deputy chairman of the Rajya Sabha as a coward. The Privileges Committee held the editor guilty of the breach of the privilege, but the committee, instead of recommending any kind of punishment against that person, they said that it would be better if the House saves its own dignity by not giving undue importance to such irresponsible articles that have been published with the sole intention of gaining cheap publicity. Right? There was another case in Maharashtra when the dance bars were banned by the government in Maharashtra. Of course, the dance bar owners were adversely affected. So the chairperson of the dance bar owner, of the dance bar association, owners association, whose name was Manjeet Sethi, he made some comment which was literally uncalled for और उसका कोई sense नहीं था, but he made it, possibly out of anger or frustration, whatever it was. And that comment was that if the government is going to shut down the dance bars, then in that case we will not even allow the wives of the ministers to move around in the city or in the state. अब इसका क्या लेना देना है इस बात से? So now this kind of a comment was made. The House found that person to be guilty of breach of privilege of the legislature, and he was sentenced to imprisonment for 3 months. Okay, so that's also an example, right? So again, what we need to understand, but the problem is that these privileges of the parliament are prone to misuse. Why? Because you have not defined them clearly in the parliament. अगर आपने इसको क्लियर लॉ में डिफाइन नहीं किया है, अगर आपने इसको डिफाइन नहीं किया है, इट मींस इट कैन बी एनीथिंग, एंड दैट इज वेयर द मिसयूज ऑफ द प्रिविलेजेस कैन हैपन. ऑफन these privileges may be used by the parliamentarians to silence their critics or people those who are not in agreement with what the parliament does. तो जैसे ओमपुरी वाला केस है, see actually what he has stated may be an over exaggeration and maybe a loose remark, but the fact is that many people in this country believe the same, they feel the same. How many people in this country are you going to punish for the breach of the privilege of the parliament for saying things like that? Also, should the parliament not introspect? If people in the country believe so, then they must find ways to improve their image rather than punishing people, those who are calling out what wrong they are doing. आप मेरी बात समझ रहे हैं कि एक किसी भी डेमोक्रेटिक इंस्टीट्यूशन को अगर कोई क्रिटिसाइज करे, उसके सामने दो ऑप्शंस हैं. या तो वो अपने क्रिटिक को साइलेंस कर दे, कैसे? उसको डरा के धमका के कि तुम ये ऐसा बोल रहे हो, मैं तुम्हारे ऊपर ब्रीच ऑफ प्रिविलेज का केस लगा दूंगा. दूसरा ऑप्शन क्या है उसके सामने? द सेकेंड ऑप्शन विच इज देयर इन फ्रंट ऑफ देम इज टू पनिश दैट इंडिविजुअल. सो दैट्स द फर्स्ट ऑप्शन, एंड द सेकेंड इज दैट दे रियलाइज कि यार इसने जो बोला है हो सकता है कि ज्यादा बोल दिया हो, बट अल्टीमेटली वी शुड ट्राई टू वर्क ऑन आवर इमेज, वी शुड ट्राई टू इंप्रूव आवर इमेज एंड नॉट ट्राई टू गेन रिस्पेक्ट बाय फोर्स. यू कैन नेवर गेन रिस्पेक्ट बाय कमांड ना. आप मतलब you win respect, you earn respect. You don't necessarily tell someone that respect me, they will not respect you. The same goes with respect to the parliament as well, है ना. So especially एक democratic body के लिए, एक democratic institution के लिए, right, that is something which we need to keep in mind. आप ये बोल सकते हैं कि नहीं भाई, बॉस की अगर कोई रिस्पेक्ट नहीं करता है कोई एम्प्लॉई, तो बॉस भी तो उसको एडमॉनिश करेगा, बट दैट इज अ डिफरेंट मैटर ऑल टुगेदर. Reason for that being because there is a certain discipline within the organization. वो कोई डेमोक्रेटिक बॉडी थोड़ी ना है, बट एक डेमोक्रेटिक बॉडी के लिए ये इंपॉर्टेंट है कि वो रिस्पेक्ट जीते, ना कि रिस्पेक्ट फोर्सफुली ले लोगों से, स्पेशली फॉर अ डेमोक्रेटिक बॉडी. सो दैट इज व्हाट वी नीड टू अंडरस्टैंड. Why is this power prone to misuse? It is a threat to democracy because of non-codification of privileges of the parliamentarians. Article 105 clause 3 authorizes the parliament to codify the privileges, but until that rely on the British privileges. Our parliament has yet not codified its privileges, and therefore it can punish the citizens for breach without even telling what the privileges are. You know? So this is something which is very draconian. Mere codification also will not grant protection to free speech. Supreme Court has held that Article 105 and 194 being special provisions would trump over 119(1)(a). Supreme Court has held that there can be no judicial review on Speaker's decision on the breach unless it is proven that the decision was an exertion of arbitrary power. So हो सकता है, suppose कीजिएगा, I make a statement criticizing the functioning of the parliament in India. For example, अगर मैं ये बोलूं, the parliament in India has become completely dysfunctional and there is voting that is taking place on important bills in the parliament without any discussion. Almost 90% of the budget in the parliament is being voted upon without any kind of discussion, and therefore parliament has literally lost the purpose with which it was created. अब ये मेरा criticism है. हो सकता है कि parliament may not like this criticism and they may punish me for the breach of the privilege of the parliament. In that case, I can go to the Supreme Court and I may claim that, sir, when they are punishing me for the breach of the privilege of the parliament by using their powers, they are violating my freedom of speech and expression under Article 19(1)(a). But the court has stated that 105 and 194 being special provisions will prevail over freedom of speech and expression in the constitution, which means that I may still be punished for the breach of the privilege of the parliament despite the fact that I may claim that मैंने तो अपना freedom of speech and expression ही exercise किया. That is something which we need to keep in mind as far as the aspects of the misuse of the breach of the privilege of the parliament is concerned. So there have been a few instances of the misuse of the breach of the privilege of the parliament. For example, there was in 2017 in one of the newspapers in Karnataka a defamatory article that was published against the MLA who also incidentally was the Speaker of the Legislative Assembly of Karnataka. So the Speaker took suo motu cognizance of that particular article and he raised that matter with the Privilege Committee of the House. Privilege Committee of the House was headed by the Speaker only, and they recommended action against that particular newspaper's editor. Now this in itself, you see how undemocratic this is. कि आपको किसी ने क्रिटिसाइज किया, आपने अपना खुद का एक कमिटी बनाया और आपने उस इंडिविजुअल को पनिश कर दिया. प्रिंसिपल्स ऑफ नेचुरल जस्टिस का वायलेशन है और एंड मोर इंपॉर्टेंटली दिस इज ऑल्सो अ वायलेशन ऑफ फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन ऑफ द सिटीजंस. अगर एक डेमोक्रेसी में सिटीजंस पार्लियामेंट या पार्लियामेंटेरियंस या लेजिस्लेटर्स को क्रिटिसाइज नहीं कर सकते हैं तो फिर एक डेमोक्रेसी का मतलब क्या है? That is the point. So that is what we need to keep in mind. The assembly imposed a 1-year sentence on the journalist. The final decision was of the speaker, who was one who had lodged the complaint against the journalist, जिसके against ये article लिखा गया था. High Court stepped in and stayed the jail sentence. Similarly, in 2019, there was a parody video of the former Chief Minister of Maharashtra delivering a speech in the House. एक parody video बनाया गया. That was taken as an insult to the House and it was considered as a breach of parliamentary privileges. See, if even parody videos, cartoons, humor that is being used by people to criticize the institutions of democracy in parliament is hurting the image of the parliament so much that they are going ahead and punishing people for the breach of the privilege of the parliament, then there will be nothing that will be left of democracy. So this is the possibility of misuse of the privileges of the parliament. I hope you understand this. But अब सवाल ये आता है, why has parliament not codified the privileges? What could be the reasons for the non-codification of the privileges of the parliament? What do you think could be the reasons? What could be the possibility? Yes? Yes. By codification of the privileges, parliament would curtail its own powers. Why? Because see, जब तक अनडिफाइंड है तो आप किसी को भी ब्रीच ऑफ प्रिविलेज के लिए पनिश कर सकते हैं क्योंकि वो तो अनडिफाइंड है और डिफाइन कौन करेगा? पार्लियामेंट ही करेगी. तो इसीलिए जब तक पेपर पे नहीं लिखा है, यू कैन यूज इट एज अ टूल टू पनिश एनीवन एंड बाय डिफाइनिंग देम आप इसको ब्लैक एंड व्हाइट में अपनी पावर्स को लिमिट कर देंगे. दैट इज वन. व्हाट कुड बी द अदर रीजन? यस, एब्सोल्युटली. It would create a conflict between the privileges of the parliament and the fundamental right to freedom of speech and expression. आपने suppose कीजिए एक law बना दिया to codify the privileges, and one of those privileges says that if there is any criticism that is taking place of the parliament, then that can be considered as a breach of privilege of the parliament. Now, we know that no law in this country can be against the provisions of the fundamental rights. So in that case, there is a possibility that the court may strike down such a privilege as well. That would again further limit the powers of the parliament or the legislature to punish an individual or a person for the breach of the privilege of the parliament. So that is another thing which we need to keep in mind. So what are the reasons for non-codification of the privileges of the parliament? Firstly, codification of these privileges may put them in direct conflict with various fundamental rights, especially the freedom of speech and expression under 19(1)(a), and therefore allow the courts to enter into such matters and create unnecessary litigation. Secondly, the vagueness due to non-codification works in the favor of the parliament as it can apply them in an arbitrary manner. The parliament believes that there have been very few instances of misuse of these privileges and therefore there is no pressing need to codify them. एक तीसरा रीजन ये भी है, पार्लियामेंट बोलती है कि भाई बहुत ही कम इंस्टांसेस हुए हैं वेयर द प्रिविलेजेस ऑफ द पार्लियामेंट हैव बीन मिसयूज्ड. तो जब मिसयूज के इतने कम इंस्टांसेस हुए हैं तो व्हाई स्पेंड टाइम अननेसेसरली ऑन डिफाइनिंग द प्रिविलेजेस, immunities of the parliamentarians? There is no need for us to do so. And fourthly, it is often argued that specifically defining the privileges may hamper the powers of the presiding officers to take disciplinary against the erring members. Basically, अगर कोई पर्टिकुलर मेंबर हाउस के अंदर रकस क्रिएट कर रहा है, हाउस को चलने नहीं दे रहा है, तो यूजुअली क्या होता है that the committee of the parliament recommends action against them and they may be suspended or expelled from the house. But if you will define the privileges specifically, and if an act does not fall into the violation of the privileges, it can go unpunished by the house. And therefore, the overall power that the presiding officer has to run the house in a proper manner will be reduced. So that's why, again, it is important that the privileges not be defined. So these are some of the reasons. By the way, UPSC has asked 2 questions on this topic. Once UPSC asked that what are the parliamentary privileges, etc., and all of that, and then they had asked what are the reasons for the non-codification of the privileges of the parliament, and does that hamper the exercise of fundamental rights in the country? इसी तरीके का एक ये क्वेश्चन आई थिंक 2013 के एग्जाम में यूपीएससी ने मेंस एग्जाम में पूछा था, और उसके बाद अभी 2018 या 19 में सिमिलर टाइप का एक और क्वेश्चन यूपीएससी ने privileges के related पूछ लिया. So this is an important topic. 2 questions have already been asked, and I always say that if a question has been asked in the mains examination, it may be asked in the prelims examination in some form or the other. So what is the way ahead with respect to privileges? एक conclusion क्या दे सकते हैं इस तरीके के questions के अंदर या इस तरीके के topic में हम? First is, Parliament fears losing its supreme power when codified law would come under judicial scrutiny. This is affecting the fundamental rights of the citizens and it is not a way the democracy should function. तो Parliament क्यों नहीं कर रही है codify privileges? Because they fear that they will lose their powers. But in a democracy, this is not how things should function. Democratic institutions should be open to criticism. So, knowing the intention of the parliamentarians, which is to essentially shield themselves and to give themselves unlimited power, the Supreme Court may, I am not saying Supreme Court should, may give the legislature a deadline for codifying its privileges so that further abuse of the privileges is prevented. Now, see, what you must understand is ideally Supreme Court should not do this. Why? Because then what if the parliament gives a timeline to the Supreme Court that you must dispose of cases within this much amount of time? You don't want that situation to occur, है ना, कि एक जो organ है दूसरे organ की functioning में interfere कर रहा है इंडिया में. But at the same time, अगर parliament खुद इसको define करने के लिए राजी नहीं है और इसकी वजह से बार बार citizens के fundamental right कर्ब हो रहे हैं, तो फिर तो कोर्ट को एंटर करना पड़ेगा इस डोमेन में और उनको एक डेडलाइन सेट करनी पड़ेगी कि आप इतने समय के अंदर पार्लियामेंट्री प्रिविलेजेस बनाइए. एक्सट्रीम सिचुएशन क्या होगी कि अगर पार्लियामेंट तब भी ना करे तो फिर कोर्ट ही बोलेगी दैट दीज आर द प्रिविलेजेस ऑफ द पार्लियामेंट, दे विल फिल दैट वैक्यूम व्हिच हैज बीन क्रिएटेड ड्यू टू एब्सेंस ऑफ लॉ. बट आइडियली वहां तक बात नहीं जानी चाहिए. कोर्ट को भी रिफ्रेन करना चाहिए ऐसा करने से, और पार्लियामेंट को भी यह समझना चाहिए दैट दे हैव अ रिस्पॉन्सिबिलिटी एंड दे शुड नॉट do things which are uncalled for. They should not do things which would lead to violation of the rights of the citizens. Secondly, finally, unless the privileges are codified, जब तक पार्लियामेंट अपनी प्रिविलेजेस कोडिफाई नहीं करती है, एंड relationship between the privileges and the fundamental rights is balanced, the present scenario should be improved. We should try to improve the present situation. How? One possible solution could be making the privilege committee as impartial as possible. जितना हो सके जो privileges committee है पार्लियामेंट की उसको impartial कर दिया जाए. उसके लिए you can ensure that the person who is involved in that breach of privilege case should not be a member of that committee. Principles of natural justice should be followed in case of functioning of the privilege committee and some things like that. So, since it's the committee that recommends whether there has been a breach and what punishment should be given to the person, it should follow all the procedures of natural justice or principles of natural justice so as to ensure and instill faith in the people कि अगर हमारे खिलाफ ब्रीच ऑफ प्रिविलेज की प्रोसीडिंग्स होंगी भी तो वो फेयर होंगी, वो केवल वेंडेटा के पर्सपेक्टिव से नहीं होंगी, वो केवल विंडिक्टिव नहीं होंगी. दे वुड बी डन इन अ फेयर एंड एन इम्पार्शियल मैनर. सो दीज आर सम ऑफ द थिंग्स दैट यू कैन सजेस्ट. एज आई सेड, न्यूमरस क्वेश्चंस हैव बीन आस्क्ड ऑन दिस. दो क्वेश्चंस तो पूछे ही गए हैं. You please have a look at those questions and try to answer those questions on the basis of the discussion that we have had. Broadly, what you need to understand is what do you understand by immunities and privileges of the parliamentarians? Secondly, what are the different type of privileges enjoyed by the parliamentarians and legislators in India and what are their sources? Third is that why the codification of these privileges has not been done. Fourth is what is the impact of non-codification of these privileges and how it leads to misuse of those particular non-codification of these privileges. Fifth is that how the parliament can punish a person for the breach of the privilege of the parliament or a state legislature can do so. And sixth is that what should be the way ahead with respect to this. So these are some dimensions that you should cover upon in your preparation of this topic. Is that clear? Parliamentary privileges and immunities. Questions that you have. And then we go into a break, and after the break we will take up the topic of parliamentary committees. Anything that you may not have understood, if you want me to repeat something. Any questions, any doubts that you have in your mind? No questions? Okay. So we'll go into a break right now, and after the break we will take up the topic of parliamentary committees. Once we are done with that topic, we will cover one aspect of the state legislatures, which is basically legislative councils, their composition, and state legislative assemblies, criticisms of legislative councils, their functioning, etc., and what happens in case of a bill in a legislature of a state that has two houses. If we are able to cover all these topics today, then we will start with the center-state relations also in today's class. Okay, I'll see you in a few minutes. So now let's quickly talk about the topic of parliamentary committees. As we have discussed that the discussion in the parliament is not always something which is very efficient and effective, simply because of the size of the parliament and also because the character of the parliament as an institution that consists of laymen politicians who may not necessarily have expertise in specific matters. As a result of that, there is always a possibility that important issues or important aspects of the functioning of the government may go unnoticed in the parliamentary functioning or scrutiny by the parliament. And that is where parliamentary committees come in. Parliamentary committees are nothing but these are subgroups, smaller groups of the parliament that consist of the parliamentarians only, which have been created with the purpose of strengthening the accountability of the executive to the parliament. As I have discussed with you, these parliamentary committees are supposed to consist of selected members of the parliament who may have specific expertise in areas, and also because the discussions take place behind the closed doors, because they happen in smaller groups, they are able to enforce greater accountability on the government of the day. Now, there are different types of parliamentary committees which are there and different ways in which we can classify the parliamentary committees. Parliamentary committees may be either ad hoc parliamentary committees or standing parliamentary committees. Ad hoc parliamentary committees are formed from a time to time basis for meeting a specific purpose or a demand. Once they fulfill that demand or that purpose, after that they are dissolved. For example, in order to examine the provisions of the Data Protection Bill, a joint parliamentary committee of Lok Sabha and Rajya Sabha had been formed, which looked into and examined the provisions of the bill, gave its report, and after that the committee was dissolved. But there are certain standing committees of the parliament that are permanent committees of the parliament, which doesn't mean that their members don't change. Their members keep changing on a periodic basis, maybe annually or maybe 2 years, but these committees continue to exist forever. These committees are supposed to perform functions that have been assigned to them by the law or the rules and the procedures of the parliament. For example, we have discussed about the 24 department related standing committees of the parliament, which play a very important role in scrutinizing the demand of grants that are put up by the government in the parliament. Apart from that, they are also supposed to scrutinize the legislations put up by the respective ministries and departments in the parliament. For example, if a bill has been introduced by Ministry of Road Transport in the Parliament of India, then the department related standing committee on transport and infrastructure would be looking into the various aspects of this bill and providing their report so that the parliament can do its functions effectively. You must understand one more thing. Parliament only has 3 sessions in a year. On an average, the number of days that the parliament functions in India today is 100 days out of 365 days. Also, it's not that those 100 days, all the days are effectively utilized, because a lot of time goes wasted in disruptions as well. And then because again, the parliamentary debates are published on the national television, people tend to say things which may not necessarily be in the interest of sound economics or policy making, but things that will impress the voter more. So in that situation, the actual debate, the actual analysis of the bills and of the provisions of the budget goes missing, and that is where these standing committees come in. There are a few other standing committees of the parliament as well, which have been mentioned in the rules and the procedures of the parliament. For example, there is a committee called as the Public Accounts Committee, which is supposed to scrutinize the reports prepared by the CAG of India on the expenditure and the revenue account of the government. Similarly, there is a committee called as the Estimates Committee that is supposed to estimate that is supposed to analyze the estimates that have been proposed by the government in the budget and to find out any kind of discrepancies in the same, right? Similarly, there is a Privileges Committee that is supposed to ensure that if there are any privileges of the parliament that have been breached, then what the punishment should be given for that, whether breach of privilege has happened or not. They also are supposed to define the privileges of the parliament. Then there is an Ethics Committee which has been in the news that is supposed to define the various ethics and rules according to which the parliament should function, and in case if any of the parliamentarian has acted contrary to those rules and ethics of the parliament or of the house. So this is the kind of committees that we have. Now in this, what you must understand is, in mains question, UPSC has asked quite a few questions on committees, but ऐसा क्वेश्चन नहीं आएगा कि आपको एक स्पेसिफिक कमिटी की फंक्शनिंग पूछ ली जाएगी, एक्सेप्ट मे बी अ फ्यू कमिटीज, बिकॉज देखिए कमिटीज ऑफ पार्लियामेंट बहुत सारी हैं. There is a committee on women, there is a committee on subordinate legislation, there is a committee on ethics, there is a committee on privileges. You can't remember composition and functioning of each of the committees, but broadly you must understand the concept of the committee. So first let's have a look at the kind of questions that have been asked in the mains examination to begin with, because in the last few years this has gone on to become a very important topic in the exam. So for example, these are 2 questions that have been asked recently, but those are 2021 में भी एक question पूछा गया committees के ऊपर. Then there was a question that was asked in 2020 as well. So almost every year they are asking a question since last 4-5 years on committees. For example, in 2018, why do you think committees are considered to be useful for parliamentary work? तो आपको वही सब लिखना होगा. Why the committees are useful? What is the advantage of committee in helping the parliament in doing its function properly? Second part of the question was, discuss in this context the role of the estimates committee. So you had to discuss what the estimates committee is, briefly discuss its composition, and also discuss what is the major role that is performed by the estimates committee. So here they have asked a specific question on functioning of a committee, but it doesn't mean that you should know the functioning of all the committees of the parliament. Estimates committee is important, PAC is important, department related standing committees are important, or any committee that has specifically been in news that year. For example, this year ethics committee has been in news. So they may ask a question on that. But ऐसा नहीं कि randomly suddenly out of the blue UPSC कुछ भी question पूछ लेगी और आपको सब कुछ याद करके जाना है. Understand that. Second is, another question was asked that do department related parliamentary standing committees, हमने अभी बात करी ना department related standing committees की budget और legislation के context में, keep the administration on its toes and inspire reverence for parliamentary control. Do they help to keep the administration on their toes, always keep a check on them, and also ensure some kind of reverence, that is some kind of respect for the parliamentary control over the executive? They are asking this question. So now if it's a question, then that means that you will say that yes, this is how these committees are useful in ensuring control on the executive, but you would also talk about some of the shortcomings as well, no? Because question mark hai na, do they actually keep the administration on toes and reverence for parliamentary control, or does it not happen? You have to talk about that. Evaluate the working, therefore it says, of such committees with suitable examples. So you had to give some examples of a few committees of the parliament that have been able to enforce accountability on the executive in India, right? So these are the questions, like example of questions. So once Woodrow Wilson, the former president of United States of America, who is also said to be the father of public administration, one of the most learned American president, had said that it is not far from truth to say that the Congress in session, Congress means parliament in America, the Congress in session is Congress on public exhibition, while the Congress in committee rooms is Congress at work. So what he is trying to say is that when the session of the Congress is going on, whatever happens in the proceedings of the Congress is more for the people, for the voters, because it is for public display. But the actual work of the Congress takes place in the committees. जैसा हमने बजट में भी देखा, मैंने आपको क्या बताया कि 97% ऑफ द बजट तो विदाउट डिस्कशन पास हो जा रहा है पार्लियामेंट में, 1 घंटे में पास हो जा रहा है, पर एक्चुअल काम कहां हो रहा है? कमिटीज में. डेटा प्रोटेक्शन बिल के ऊपर पार्लियामेंट में तो केवल 2 घंटा डिबेट हुई है, बट एक्चुअल वर्क ऑन डेटा प्रोटेक्शन बिल हैपेंड इन दी पार्लियामेंट्री कमिटी दैट recommended changes and analyzed the provisions of the data protection bill and suggested what are the changes, amendments that should be brought in the bill in order to correct the lacuna that exist in the bill. So actual work happened there is what I am trying to tell you. So therefore, parliamentary committees are composed of groups of MPs. So these are subgroups of the parliament. These committees review proposed laws, oversee activities of the government, and scrutinize the government expenditure. Their reports allow for informed debate in the parliament as well as increases the efficiency and expertise of the parliament. Parliament lacks expertise and time, and these committees fill that particular gap. Committees also provide a forum to build consensus across party lines without keeping in mind which political party you belong to, because as I said, their meetings happen behind the closed doors. They enable consultations with independent experts and stakeholders also. So you can always get the outsiders to provide consultation to the committees. As I told you earlier as well, the committees of the parliament may even seek suggestions from the public on bills, on various government functioning. that also helps to ensure that citizen participation can become a reality in the democracy. And lastly, the government is required to table an action taken report on the committees of the House, for the House to judge the progress made on the suggestions of the committee. So action taken report is essentially nothing, but whenever a committee of the Parliament makes any kind of suggestions in its report, the government along with the committee report is supposed to table an action taken report in the Parliament as to what recommendations they have accepted and what they have not. And why have they not accepted certain recommendations? That would help in ensuring that the Parliament can then ask questions from the executive. Why did you not implement so and so specific recommendation, etc. of the committee? What have you done on this particular aspect of the recommendation of the committee? तो ये एक तरीका बन जाता है parliamentary accountability enforce करने का on the executive. So these are the advantages, these are the benefits of the committee system that has been created in India. Now, one of the ways, as I told you, of classifying the committees in the Parliament is to classify them as either ad hoc or as standing committees. Ad hoc committees are the ones, as I told you, which are formed for a specific purpose. Once they achieve that purpose, after that they are diluted. Standing committees are the permanent committees of the Parliament of India that continue to exist. But you must understand that doesn't mean, as I have told you, that their membership is permanent. है ना, ऐसा नहीं है कि इसकी मेंबरशिप परमानेंट है. अब देखिए, कमिटीज के मेंबर्स चूज कैसे किए जाते हैं ये भी वेरी करता है कमिटी टू कमिटी. In some committees, members are nominated by the presiding officer as members, depending upon the strength of the party in the House. In some committees, the members are chosen through an election process within the House. So that also, of course, is dependent on the number of seats that a particular political has in the House, right? So it depends how the members are chosen. In some cases, they may be by nomination from the political party. In some cases, they may be by election within the House, or in some cases, they may be nominated by the presiding officer of the House. But you must understand one very clear thing, that we don't need to get into all those kind of details. Reason being, all of this is then getting into rules and procedures of the Parliament, which is beyond the scope of our preparation. Why? Because rules and procedures of the Parliament in itself are very complicated and very elongated. अगर आप केवल पार्लियामेंट के रूल्स एंड प्रोसीजर्स ही पढ़ने लग जाएंगे तो यू विल नॉट गेट एनफ टाइम टू रीड रेस्ट ऑफ द कॉन्स्टिट्यूशन एंड प्रिपेयर फॉर द एग्जाम. सो देयरफॉर वी हैव टू नो वेयर वी हैव टू रिस्ट्रिक्ट आवर इंफॉर्मेशन. बेसिक चीजें पता होनी चाहिए बस आपको कमिटीज के बारे में. अदरवाइज अभी आपने क्वेश्चंस भी देखे, यूपीएससी क्वेश्चन जो पूछ रहा है वो थोड़े ब्रॉड क्वेश्चंस पूछ रहा है. उसमें वो एक स्पेसिफिक एस्पेक्ट पूछ लेता है, बट दैट ऑल्सो इज नॉट वेरी डिटेल्ड थिंग्स विच दे आर एक्सपेक्टिंग. They are expecting you to write more about parliamentary control through committees. They are expecting you to write more about the administrative control through the parliament, through the committee route, etc. वो सब चीजें ज्यादा पूछ रहा है वो. So anyway, what are the different type of what are the important standing committees of the Parliament of India? Firstly, so some of the important standing committees, ad hoc committees तो देखिए ये तो टाइम टू टाइम वेरी करती रहती है ना. स्टैंडिंग कमिटीज के बारे में बात कर लेते हैं. वन ऑफ द इंपॉर्टेंट स्टैंडिंग कमिटीज ऑफ द पार्लियामेंट इज डिपार्टमेंट रिलेटेड स्टैंडिंग कमिटीज. देयर आर 24 डिपार्टमेंट रिलेटेड स्टैंडिंग कमिटीज. ईच वन ऑफ देम हैज 31 members, 21 members from the Lok Sabha and 10 members from the Rajya Sabha. They help the parliament in scrutinizing the demand of grants that have been put forward by the executive in the budget. And secondly, they also play a very important role in scrutinizing the legislation. Department related standing committees may also analyze the functioning of the government departments and ministries as well from time to time and create reports on the same. Say for example, department related standing committee on health and women and child development may come out with a report on the status of women in India and measures that should be taken to improve them. Department related standing committee on home affairs had published a committee on published a report on improving the situation of the central armed police forces and their functioning in India. They had published a report on dealing with the insurgency situation in northeast India, and what are the challenges that need to be addressed going ahead in future with respect to northeast insurgency. The point that I am basically trying to make here is that you must know that these committees that have been created in these manner have a specific type of function. तो एक तो डिपार्टमेंट रिलेटेड स्टैंडिंग कमिटीज हैं, उसके अलावा कुछ फाइनेंशियल कमिटीज हैं पार्लियामेंट की जो कि फाइनेंशियल डोमेन में स्पेसिफिकली एक बहुत इंपॉर्टेंट रोल प्ले करती हैं टू एंश्योर अकाउंटेबिलिटी ऑफ द गवर्नमेंट टू द पार्लियामेंट. वन कमिटी इज पब्लिक अकाउंट्स कमिटी, then we have committee on public undertakings, we have estimates committee. They ensure that public finances are used in an efficient manner. There are some standing committees which are administrative committees as well, जो कि parliament की administration या running में help करती हैं. Business advisory committee of the parliament is supposed to create a agenda for the functioning of the parliament. Similarly, we have the rules committee of the parliament that is supposed to ensure the make the rules for the functioning of the parliament and enforce those particular rules on the in the functioning of the parliament and see if someone is violating those rules, etc. Similarly, there are committees on government assurances, committee on subordinate legislation, etc. that are accountability committee. As you people would know, the government often makes subordinate legislation under a law made by the Parliament of India. Is that subordinate legislation well within the law or not? This is examined by Committee on Subordinate Legislation. Is that subordinate legislation giving excessive powers to the government or not? This is examined again by the Subordinate Committee on Legislation. It comes out with its reports from time to time, and that becomes the fodder for the parliamentarians to enforce accountability on the executive. Before I get into the details of some of the committees of the parliament, such as Estimates Committee and Public Accounts Committee, you must ensure, or you must understand, that ultimately the effectivity of committees and their functioning will depend upon how effective the parliamentary functioning is. What I mean to say is, let us say कि estimates committee ने अपनी report दी कि parliament government ने ये जो estimates दिए थे उसमें ये सब गड़बड़ है. अगर उस estimates committee की report पे discussion ही नहीं होगी, if there would be no discussion in the parliament, then what is the point of the committee of report of the committee? You get my point? So basically, the functioning of the committees is not just dependent on how effective the committees themselves are, but on the parliament as well, because ultimately committees are supposed to aid the parliament. If parliament itself is not functioning, it is getting disrupted, or there are no questions that are being asked in the parliament on the basis of the reports of the committees, then the committees themselves do not really serve any purpose. So this is also something which you need to keep in mind. So now let's talk about some of the important financial committees of the parliament. So you may give the heading important financial committees. दो तीन committees के बारे में लिख लीजिएगा. Important financial committees of the parliament. I am discussing only estimates committee and the committee on public undertakings right now. Public accounts committee I will discuss when I will take up the topic of CAG, because CAG and public accounts committee work hand in hand with each other. वो दोनों एक separate topic हैं. Anyway, so you please write down. First is estimates committee. तो estimates committee of parliament कि क्या functions होते हैं, क्या composition होता है. You please write that down quickly. So please write down. It consists of 30 members. It consists of 30 members, all of which are it consists of 30 members, all of which are drawn from the Lok Sabha. All of which are drawn from the Lok Sabha. This committee is chosen through an election process. This committee is chosen through an election process based on the principle of based on the principle of proportional representation based on the principle of proportional representation by a means of single transferable vote. By a means of single transferable vote. It is also called the twin sister. It is also called the twin sister of. It is also called the twin sister of the Public Accounts Committee. It is also called the twin sister of the Public Accounts Committee. Please write down functions of the Estimates Committee. Function of Estimates Committee. It selects a handful of ministries every year it selects a handful of ministries every year and looks at their current and previous year estimates looks at their current and previous year's estimates and trends of growth of expenditure. And trends of growth of expenditure. So you select a few ministries every year as estimates committee and you see that what was the expenditure that they had made last year, what has been the growth in the expenditure for the ministry this year with respect to estimates that they have submitted, and see that what is the trend. If they are asking for, let's say, 500 crores this year and they had only spent 300 crores last year out of the 500 crores that they had asked last year, why are they asking for 500 crores this year again? So that kind of observation is made by the estimates committee. Next, please write down. On the above basis, it tries to identify those areas. On the above basis, it tries to identify those areas where the expenditure can be minimized. It tries to identify those areas where the expenditure can be minimized by introducing reforms. By introducing reforms in administration. By introducing reforms in administration. तो ये वो एरियाज भी आइडेंटिफाई करने की कोशिश करता है जहां पे एक्सपेंडिचर कम किया जा सकता है बाय ट्राइंग टू रिड्यूस द एडमिनिस्ट्रेटिव costs or by trying to reduce the extravagant expenditure which has been made by the ministry or the department in the past. So it scrutinizes those things in a very detailed manner. Next, please write down. It is not supposed to question the policy of the government unless in very rare circumstances where the policy itself is extravagant. unless where the policy itself is extravagant. अब देखिए ये ना बड़ा समझना जरूरी है what this line is. This will give you clarity on exactly estimates committee करता क्या है, अगर आप इसको पिछले पैराग्राफ के साथ रिलेट करके पढ़ें तो. Let us say that there is a particular government ministry which has submitted a demand of grant for X amount of money in that particular financial year. Estimates committee will not say that आपको ये X amount of पैसा क्यों चाहिए, क्योंकि ये काम तो डिपार्टमेंट रिलेटेड स्टैंडिंग कमेटी कर रही है ना, ऑफ एनालाइजिंग द पॉलिसी ऑफ द गवर्नमेंट. भाई दैट डिपार्टमेंट मस्ट हैव सेड कि मेरे को ये X पैसा, इसमें से A amount of money is required for this purpose, B for this purpose, C for this purpose, D for this purpose, E for this purpose. Department related standing committee will say नहीं, why do you need A के लिए A for X for this purpose, why do you need A amount of money? You can do it in so much amount. For this purpose, why do you need B amount of money? You can do it in so much amount of money. Or why do you need to do this in the first place? ये पॉलिसी की बात है. सपोज कीजिए किसी एक पर्टिकुलर मिनिस्ट्री ने बोला है कि हम स्कूल्स बनाएंगे, मिनिस्ट्री ऑफ एजुकेशन ने, एंड इन दो स्कूल्स वी विल सेट अप स्मार्ट क्लासरूम्स. इन एवरी क्लासरूम देयर विल बी अ सैटेलाइट टेलीविजन दैट वुड बी पुट अप. In every classroom we will have a smart screen, etc., all of this thing. Now the department related standing committee will say that if your objective is to improve the learning outcomes, then you don't need any smart classrooms, rather you should invest in training of the teachers. And therefore in our opinion, this 50 crore rupees that you have demanded for setting up smart classrooms, there is no need for this demand. You should cut down this demand. This is called as analyzing the demand of grant and policy. What will the estimates committee do? The estimates committee will look into कि इस पर्टिकुलर मिनिस्ट्री ने 50 करोड़ मांगे हैं स्कूल सेटअप करने के लिए, इसमें से 40 करोड़ तो चाहिए फॉर इंफ्रास्ट्रक्चर ऑफ द स्कूल, बट 10 करोड़ दे आर आस्किंग फॉर द स्टाफ दैट विल बी डिप्लॉयड फॉर मॉनिटरिंग द कंस्ट्रक्शन ऑफ द स्कूल. उनकी सैलरीज देने के लिए इन्होंने 10 करोड़ रुपया मांग लिया है. वाई इज दिस मच अमाउंट ऑफ मनी रिक्वायर्ड फॉर एडमिनिस्ट्रेटिव पर्पसेस? इट शुड बी कट डाउन. सो दे विल लुक इनटू एडमिनिस्ट्रेटिव रिफॉर्म्स, एडमिनिस्ट्रेटिव एस्पेक्ट्स, कि क्या एक काम को करने के लिए जिसमें गवर्नमेंट ने 10 लोग लगाए हुए हैं, क्या उसको 5 लोगों के साथ किया जा सकता है? कैन दैट बी डन विद 5 पीपल? ये है एडमिनिस्ट्रेटिव रिफॉर्म. और if there is a particular policy of the government in which they, or in a particular scheme of the government in which they take 10 steps, can those 10 steps be cut down to 5 so as to ensure efficient functioning of that scheme or program of the government? So they will look into administrative reform aspects and not policy aspects. They will not say कि ये 50 करोड़ रुपए से तुम स्कूल क्यों बना रहे हो, इससे टॉयलेट बनाओ. They won't say that, but they will say that out of 50 crore rupees, if you are creating schools, why do you need X amount of money for paying the salaries of the staff? Why can't this be done in X minus Y? That is what they will do. Do you understand what I am trying to say? Difference है policy reform और administrative reform में. ये administrative reform के ऊपर focus करती है estimates committee. Next, please write down. It suggests to the executive the form in which It suggests to the executive the form in which the budget should be presented to the parliament. It suggests to the executive the form in which the budget should be presented to the parliament. मतलब जो आप मैनर ऑफ प्रेजेंटेशन ऑफ बजट होगा, जो टेबल्स आप बनाएंगे, जो आपके कैटेगराइजेशन होगा, वो कैसे होना चाहिए जैसे कि पार्लियामेंट उसको बेटर तरीके से समझ सके उन एस्टिमेट्स को. दैट इज व्हाट इट सजेस्ट. इट इज ऑफन टर्म्ड एज स्टैंडिंग कमिटी ऑन एडमिनिस्ट्रेटिव रिफॉर्म्स. स्टैंडिंग कमिटी ऑन एडमिनिस्ट्रेटिव रिफॉर्म्स. CAG in India is supposed to primarily perform the auditing function, audit the accounts of the government. But CAG also performs what is called as accounting function, or used to perform accounting function, where the CAG used to maintain the accounts of the government and audit them as well. But then the estimates committee noticed that as a result of this, the CAG spends most of its time only on accounting and not on auditing, so the major function is missing. इसीलिए CAG का ऑडिटिंग फंक्शन अलग कर दिया जाए और अकाउंटिंग फंक्शन किसी और बॉडी को दे दिया जाए, so that CAG can focus only on audit. And as a result, in 1971 we passed a law, and the accounting function, maintaining the accounts of the union government, was taken away from the CAG and was given to the Controller General of Accounts in India. तो ये एक एग्जाम्पल है कैसे एस्टिमेट्स कमिटी ने रिफॉर्म सजेस्ट किया इन दी एडमिनिस्ट्रेटिव एस्पेक्ट. सो प्लीज राइट डाउन. फॉर एग्जाम्पल, इट सजेस्टेड द सेपरेशन ऑफ auditing function from the accounting function of the executive. Accounting function of the executive. Accounting function of the CAG, sorry. Accounting function of the CAG. The estimates committee was also responsible for introduction of performance budgeting. The estimates committee was also responsible for the introduction of performance budgeting, making the government functioning highly effective. Introduction of performance budgeting, making the government functioning highly effective. Performance budgeting बोले तो where basically in the performance budgeting or performance accounting you will not only see कि क्या गवर्नमेंट ने जो जितना पैसा उनको एलोकेट किया गया था उसको स्पेंड कर दिया कि नहीं, but it will also look at performance of the government. So government said that out of 500 crore rupees we will create 50 schools. Whether those 50 schools were created or not is just input output accounting or budgeting that you are doing, but you would also look at what was the reason for which you wanted to set up those schools, to educate masses, to educate children. So how many children have actually been educated in those schools? ऐसा नहीं बस स्कूल की बिल्डिंग खड़ी कर दी है, but no education has been given. So that is what is called as performance budgeting. And last, please write down, it is also called as the continuous committee of the parliament. It is also called as the continuous committee of the parliament, as it continuously looks into the expenditure made by the parliament. Continuously looks into the expenditure made by the parliament. Continuously looks into the expenditure made by the parliament. Right? So this is about estimates committee. Then we have committee on public undertakings. उस पे लिख लीजिएगा. We will discuss about PAC as I told you later. Committee on public undertakings. It consists of 22 members. It consists of 22 members, 7 from the Rajya Sabha, 7 from the Rajya Sabha, and 15 from the Lok Sabha. And 15 from the Lok Sabha. Its members are elected every year. Its members are elected every year. Are elected every year from the House on the basis of from the House on the basis of single transferable vote and proportional representation. Single transferable vote and proportional representation. So please write down, it examines, functions क्या है इस कमेटी की? It examines the reports of the PSUs, it examines the reports of the PSUs and the CAG's report and the CAG's reports on the functioning of the PSUs. So annual reports of PSUs and CAG's reports on the PSUs. CAG's reports on the PSUs. It is supposed to examine if the PSUs are administered it is supposed to examine if the PSUs are administered according to sound business practices comma good commercial principles corporate governance norms etc. It analyzes the functioning of only selected PSUs every year. It analyzes the functioning of only selected PSUs every year. Functioning of only selected PSUs every year. I hope that this is understood to everyone. Now, what are some of the best examples of some practices by the committees in the past have been mentioned here? जब पहली जो पार्लियामेंट थी, जो कॉन्स्टिट्यूएंट असेंबली भी थी, उसकी एक कमेटी बनाई गई थी विच वाज नॉर्थ ईस्ट फ्रंटियर ट्राइबल एंड एक्सक्लूडेड एरियाज सब कमेटी विच हैड रेकमेंडेड inclusion of provisions related to Schedule 6. There was another committee, excluded and partially excluded areas other than Assam subcommittee of the parliament, which was chaired by Jaipal Singh Munda, which had recommended the inclusion of provisions related to Schedule 5 in the constitution. So they did tremendous amount of work that helped in inclusion of special provisions for the scheduled tribes in the constitution. Similarly, there was a committee on personnel, public grievance, law and justice that was created, which suggested some of the shortcomings in the way the grievance redressal mechanism functions in India, and also suggested setting up of CP Grams, which is the central government's portal for grievance redressal mechanism. So if you have a grievance against any central government officer, you can go and register it on the CP Grams portal. ये जो recommendation है या जो ये change है, that was made on the recommendation of the department related standing committee on the public grievances. Similarly, you people would know that in 2015 PSC had highlighted, the Public Accounts Committee had highlighted the kind of policy changes which were being made with respect to the shipyard manufacturing in India and how it was resulting in inefficiencies. And as a result of that, the government came to know of the challenges, government got the feedback and incorporated that feedback into the functioning of the shipyards in India. Not just that, but when we will discuss about Public Accounts Committee in future, we will discuss that how Public Accounts Committee report is what went on to become the major talking point for the 2G scam in the country, right? CAG की जो report आई 2G spectrum allocation के ऊपर, उस पे Public Accounts Committee की जो report बनी, that is what created the furor in the country, and that is how the government accountability could be fixed with respect to the entire 2G spectrum allocation in the country. Anyway, so that's what we can say are some of the achievements of the committees of the parliament in the past. If you read newspapers, you will come across a few current affairs examples as well. You can include those as well, right? You can give example of, let's say, the data protection bill. The Joint Parliamentary Committee on Data Protection Bill did extensive work and made several recommendations and changes to the data protection bill, which would further help in strengthening of the law. Some of these recommendations were accepted, some of them were not by the government. But that goes without saying that there are certain challenges or difficulties also in the functioning of these committees. So let's have a look at that. What are some of the limitations associated with the functioning of the parliamentary committees as they exist today? Now, till 15th Lok Sabha, that is till 2014, there was a popular trend of sending the bills introduced in the parliament to the committees of the parliament for their scrutiny. This number till the 15th Lok Sabha stood as high as 76%, which meant that out of 4 bills being introduced in the parliament, 3 of them were being referred to the committees of the parliament for their scrutiny. Which means that even though parliament में बहुत ज़्यादा discussion नहीं हो रहा था bills पे, पर कम से कम committees में हो रहा था. But unfortunately, in the last 10 years, we have seen a decline in the use of the committees in the parliament for scrutinizing the legislations introduced in the parliament. The track record of the last Lok Sabha, 17th one, has been very poor when it comes to the bills referred to the committees of the parliament for their scrutiny. Only 20% of the bills introduced in the parliament have been referred to the committees of the parliament. So, in absence of any proper discussion happening in the parliament and now even in the parliamentary committees, it means that the executive has got a free hand. It can introduce a bill in the parliament and get it approved in the parliament without any kind of scrutiny, which is a very dangerous trend, because it means that the executive can make some draconian laws as well at times, and there would be no even if objections are raised, they would be put aside. तो एक तो ये बड़ा चैलेंज है कि इंडिया में सारे जो बिल्स हैं पार्लियामेंट्री कमिटीज को नहीं रेफर किए जाते हैं फॉर देयर एनालिसिस. इन कंट्रीज सच एज ब्रिटेन, the provision is that except a few bills, all the bills will go to the parliamentary committees for their analysis and discussion. So this trend needs to change, and this is something which is of course been a criticism of the functioning of the parliamentary committees in India in the recent past. Then parliamentary committees suffer on the account of shortage of staff as well. So ultimately you must understand that even though parliamentarians are parts of these parliamentary committees, they can't do all the work by themselves. They can't be making the notes, they can't be making the notes of minutes of meeting, they can't be doing up the follow-up changes in the form of preparation of report etc. ये सारा काम MPs थोड़े ना करेंगे बैठ के, because they have other important duties also to play. So therefore the standing committees of the parliament, department related standing committees etc. need staff which can assist them in their functioning. But we often find that the standing committees or the committees of the parliament are not having adequate staff to help them in their effective functioning. Third is that shortage of time has affected the comprehensive functioning of many of these committees. So often the time that is given to the committees to analyze a bill by the parliament or to analyze the demand of grants etc. is way too less for them to come out with any comprehensive report that can actually bring about transformation in governance. So shortage of time is also an issue. Also, as we have known, the reports of the committees are largely recommendatory in nature. They are not binding on the government. So what recommendations the government will actually implement or not is their prerogative. As a result of that, a lot of times they actually do not implement the recommendations. Not just that, but as I have told you, ultimately the effectivity of the functioning of the committees is dependent on the effectivity of the functioning of the parliament. अगर आप रिपोर्ट्स ही नहीं डिस्कस करेंगे कमिटीज की पार्लियामेंट में, या एक्शन टेकन रिपोर्ट नहीं डिस्कस होगी, तो उन कमिटीज का फायदा क्या? सो दैट इज अनदर थिंग which we need to keep in mind. Then on top of that, the attendance of the MPs at the meetings is not consistent. A lot of times some MPs go missing from attending the meetings of the committees, which of course compromises their functioning. And last point being, DRSCs, department related standing committees, are renewed on an annual basis that affects their specialization. So for example, I may be a member of department related standing committee on home affairs 1 year, and maybe a part of the department related standing committee on health next year, and department related standing committee on women and child the 3rd year. I may have gained some expertise in health matters as a part of being that committee 1 year, but next year मेरे को किसी और department related standing committee में कर दिया गया, फिर उसके बाद किसी और में, या हो सकता है मेरे को बनाया ही नहीं जाए next year किसी department related standing committee का member. Why? Because seats are usually allocated on a rotation basis in parties. So as a result of that, my expertise will be lost. The amount of learning that I have gained as a part of the department related standing committee would all go to waste, because now someone new will come in. That person will take 3 to 6 months to understand that sector of economy. जब तक वो समझेंगे तब तक उनका tenure खत्म हो जाएगा. So this is another problem which is there with the functioning of the committees. So how do we reform the functioning of the committees in India? Let's discuss that also. What is the way ahead? The problem of the shortage of technical staff that is supposed to aid the committee in their functioning may be addressed by recruiting young individuals, those who are interested in the parliamentary functioning and parliamentary affairs in India. Possibly we can start a fellowship that would be run by the government or by the parliament to recruit young people who may then be made a part of these committees, and they may be created as useful resources for the country going ahead in future. Some private organizations do run such fellowships, such as the PRS, but of course their intake is very low, and they only provide the interns to, or the fellows to, work with specific MPs and not necessarily with parliamentary committees, right? So possibly the government should look at seeing that how they can address this gap. One of the ways which I would suggest to the government is that any of the candidates in the UPSC civil service exam who has qualified till the interview stage must be given a direct interview for recruitment to these committees. That way you can generate employment for the youth as well, and at the same time you can strengthen the functioning of the parliament, and most importantly, young people, those who are appearing in this exam and have already gone through a certain rigor of this exam, they have come in top 2,000-3,000 candidates of this exam, that means that they are good. So why to let go of their talent? Why to waste their talent when you have already spent so much time and energy to recognize who these people are? So why not give them an opportunity to work with the government or with the parliamentary committees? That would bring more of young blood as well as good people to the system, and it would also give a way for these people, those who are appearing in the exam, an exit route or an exit option into something which may be of interest to them. Something like that could be done. Secondly, they can be given a fixed timeline to come up with the recommendations and present their report. So often it has been seen that the reports get delayed. The standing committees reports etc. take a lot of time. So how can we address that? By giving a fixed timeline in which the reports can be published. There is a need to increase the number of DRSCs, and their term may be increased beyond period of 1 year as well. तो हम 1 साल के beyond भी डिपार्टमेंट रिलेटेड स्टैंडिंग कमिटीज की के टेन्योर को बढ़ा सकते हैं, जिससे कि हम थोड़ा एक्सपर्टीज डेवलप कर सके. समथिंग विच वी आर डिस्कसिंग. The National Commission to review the working of the Constitution had suggested that some more DRSCs should be set up. जो अभी DRSCs हैं, they are not adequate to deal with the kind of workload that they have to deal with. Also, the functioning of the government has become way too complicated, and ideally for that you should have the more department related standing committees being created. You must make the attendance of the MPs to a certain extent mandatory at the meetings of the committees so as to make them more effective. We may adopt the British practice of compulsory referral of every bill introduced in the parliament to parliamentary committees except in exceptional circumstances, and during the discussions of the committee, party whip should not apply. Now see, normally party whip does not apply in case of committees meetings, but आजकल हो क्या गया है, because there is no internal party democracy, the political parties often issue a whip on how you need to say things even in the committee meetings. So as a result of that, the meetings of the committees have become more political in nature as they were earlier, which has actually defeated the purpose of creation of these committees. So these are some of the suggestions that you can write down as to reform the functioning of the committees in India, right? So again, in this topic, we should know what committees are, we should know how committees can be classified, we should know the objective or the purpose behind creation of committees, shortcomings, way ahead, as well as some specific committees of the parliament. We must know what their composition, structure, etc. is. तो वो आप एक बार अपने टेक्स्ट बुक से या मटेरियल से थोड़ा बहुत देख लीजिएगा, बट उसमें बहुत सारी कमिटीज दी हो तो सारी कमिटीज के बारे में पढ़ना जरूरी नहीं है. 2-3-4 जो कमिटीज हैं वही इंपॉर्टेंट है. कमिटी ऑन पब्लिक अंडरटेकिंग्स, पब्लिक अकाउंट्स कमिटी, एस्टिमेट्स कमिटी, या फिर कोई और एक ऐसी कमिटी जो आपको दिख रहा है कि न्यूज में आई है, और समथिंग विच हैज been covered in the current affairs. Only that committee you need to focus on. Otherwise, don't waste your time on just reading about committees, because UPSC in both prelims and mains examination doesn't really focus on rules and procedures of the parliament, because as I told you, they are already very elaborate in nature. अगर UPSC उसके ऊपर भी क्वेश्चन पूछना शुरू कर देगी, then it would become literally impossible for the student to be covering the entire subject of polity and governance as such. This is about committees, privileges, immunities of the parliament. We are done with the topic of union legislature. Any questions that you may have related to parliamentary committees, immunities or privileges for that matter? Can we proceed further? The next topic in the legislature is that of the composition and the structure of the state legislatures, and what is the procedure that is followed in case of the enactment of laws in a legislature of a state that has two houses. So firstly, let's talk about the composition and the structure of the state legislatures in India. So what is the composition and the structure of state legislatures? Please refer Article 168 and 170 to understand the composition of the state legislatures in India. Composition and structure. पहले स्ट्रक्चर समझ लेते हैं कि स्टेट लेजिस्लेचर का क्या कॉन्स्टिट्यूशन या स्ट्रक्चर होता है. स्टेट लेजिस्लेचर इज सपोज टू कंसिस्ट ऑफ लेजिस्लेटिव असेंबली and governor, and in states that are having state legislative council, a state legislative council also. So what we have in India is essentially, according to Article 168, state legislature consisting of firstly legislative assembly and governor, and in some of the state legislative councils also. State legislative councils should include, or according to the present provisions, are present for the state of UP, Bihar, Maharashtra, Andhra Pradesh, Telangana and Karnataka. These are the states that have state legislative council in India. तो या तो 2 houses होंगे state legislature के या 1 होगा, that will depend upon whatever is the provision that exists with respect to that state. Now, if we talk about the state legislative councils first, not every state has a state legislative council. The state legislative council, the process of abolition and creation has been mentioned in Article 169 of the Constitution. Article 169 provides the procedure for the abolition and the creation of state legislative councils in India. According to this provision, state legislative assembly must pass a resolution for either creation or abolition of a legislative council in the state. If a state has a legislative council, they can pass a resolution for its abolition. If a state does not have a legislative council, they can pass a resolution for creation of legislative council. This resolution must be passed by a special majority of the legislative assembly, which is nothing but majority of the total membership of the house and not less than 2/3 of members present and voting, as we have discussed so many times earlier. Now, the resolution that would be passed by the state legislative assembly would then go to the Parliament of India, expressing their views in that particular resolution. And then the Parliament as a result would pass a law, and that law would have the effect of either creation or abolition of state legislative council. क्रिएशन और एबोलिशन ऑफ स्टेट लेजिस्लेटिव काउंसिल. तो उल्टा नहीं हो सकता कि पहले पार्लियामेंट लॉ पास करे और फिर स्टेट लेजिस्लेचर रेजोल्यूशन पास करे. यही प्रोसेस हमेशा फॉलो होगा. अब यहां पर एक इंपॉर्टेंट चीज देखने की जरूरत है. व्हेन एनी स्टेट्स legislative council would be abolished or would be created, it would have an impact on Article 168 of the Constitution, because the states that can have a legislative council have been mentioned in Article 168. So the question that arises is that if the state, if the law made by the Parliament to create a legislative council or to abolish a legislative council is going to amend Article 168 of the Indian Constitution, ideally such a law should require to follow the procedure under 368 of the Constitution. But Article 169 in clause 3 and clause 2 very clearly tells us that a law which has been made by the Parliament for abolishing or creating a legislative council shall not be considered as an amendment of the Constitution under Article 368, even though it would have the effect of amending the Article 168. Do you understand that? Very similar to provisions of Article 4. A law made by the Parliament under Article 4, Article 2 and 3, even though it may amend the provisions of the Constitution including Schedule 1 and Schedule 4, such a law would not be deemed as an amendment of the Constitution under Article 368. वही same provision यहाँ पर भी exist करता है, which is that a law made by the Parliament under Article 169, this law, even though it would amend 168, it would not be considered, not be deemed as a constitutional amendment act under Article 368 of the Indian Constitution. This is essentially to ensure flexibility to the parliament for the creation or abolition of legislative councils in the state. I hope this is understood. Creation and abolition of legislative councils in the state. Now let's talk about the composition of the legislative councils first. Then we will talk about composition of the legislative assemblies. So interestingly, the legislative councils in the states, so composition of legislative council in the state. Now legislative council in any state as such is supposed to be an elected as well as a nominated house. इसमें कुछ लोग इलेक्टेड भी होते हैं और नॉमिनेटेड भी होते हैं. Elected members of the legislative council would be as follows. So basically, to remember this, you can divide the composition of a legislative council into three parts. 1/3 of the members of a legislative council are chosen by an electoral college consisting of members of legislative assembly in the state. So 1/3 will be chosen by the electoral college consisting of MLAs in the state. But these 1/3 members should not be chosen by and among the members of legislative assembly. Please understand that. They are choosing the members of the legislative councils but not among themselves. So if you see composition of legislative councils in 171, in clause 3 and subclause D, as nearly as may be 1/3 shall be elected by members of the legislative assembly of the state from amongst persons who are not members of the. Is that understood? तो ये अपने अंदर से चूज नहीं करते हैं लोगों को, but someone else. So 1/3 of the members will be chosen by an electoral college consisting of MLAs but not among themselves. Not among themselves. Is this clear to everyone? Then 1/3 of the members of the legislative councils are chosen by the members, an electoral college consisting of the members of local bodies within the state. So they are chosen by an electoral college consisting of members of local bodies within the states. If you read Article 171 clause 3 subclause A, it says that of the total number of the members of the legislative council of a state, as nearly as may be 1/3 shall be elected by electorate consisting of members of municipalities, district boards and such other local authorities as the parliament may by law specify. सो ये एक्चुअली डिटर्मिन कौन कौन लोकल बॉडीज हमने लिख दिया है, बट एग्जैक्टली कौन पार्टिसिपेट करेगा, वो जो पार्लियामेंट की लॉ होती है ना क्रिएशन ऑफ लेजिस्लेटिव काउंसिल के लिए, वही डिफाइन करती है कि इसमें एक्चुअली कौन पार्टिसिपेट करेगा. एंड देयर इज नो लिमिटेशन ऑन दीज पीपल ऑल्सो टू कंटेस्ट द इलेक्शंस. सो देयर इज नो लिमिटेशन कि ये खुद नहीं वो चुनाव लड़ सकते. बट ऑफ कोर्स दे कांट होल्ड टू पोजीशन, देन दे विल हैव टू रिजाइन फ्रॉम द position of the local body if they have to continue as a member of the legislative council of the state. Yahan pe they cannot contest themselves, but here they may also contest. Is this clear? Now the remaining 1/3 you can divide it into further two portions which will be 1/6 and 1/6. तो ये एक 1/6 हो गया और ये एक 1/6 हो गया. 1/6 of the members of these councils are chosen through nominated route. They are nominated by the governor of the state, of course not in his discretionary capacity, from the field of cooperative movement, and similar to Lok Sabha and Rajya Sabha, from literature, arts, science, and what? Social service. These are nominated by the governor. People having special knowledge and experience, expertise in the area of cooperative movement, literature, arts, science, and social service. Remaining 1/6 can be further divided into two portions. 1/12 and 1/12. So you have this 1/12 and then you have this particular 1/12. This, so 1/12 portion of a legislative council, 1/12 members, are chosen from if you read 171 clause 3, as nearly as maybe 1/12 clause 3 subclause B, as nearly as maybe 1/12 shall be elected by electorates consisting of persons residing in the state who have been for at least 3 years graduates of any university in territory of India or any such qualification of graduation by or under law made by parliament as equivalent to that of a graduate of any such university. तो मतलब इसको हम कहते हैं graduate constituency. One by 12th of the members, as it says, are chosen by an electorate. So इसमें electoral college कौन होगा? Those people who are voters in that state who have obtained graduation degree for at least 3 years. मतलब कि उनके पास कम से कम 3 साल पहले की ग्रेजुएशन डिग्री है. Recent graduates won't get this right. People, those who have been graduates for at least 3 years. Such people would be a part of the electoral college of the president of electoral college of the 1/12th of these seats in the legislative councils. Now these people, it's not necessary that these people only should contest for these seats. Contest कोई भी कर सकता है. Whoever is qualified to be contesting the elections for the legislative council. But voters कौन होंगे? Graduates for at least 3 years. Do you need to be a graduate from a university in that state only? No. You could be a graduate from any university in India or any degree which is considered equivalent to graduate degree according to the law of the Parliament of India. But you must be a voter in that state. So you must be graduate for at least 3 years from any university. किसी भी यूनिवर्सिटी के वो ग्रेजुएट होने चाहिए फॉर एटलीस्ट 3 years. बट voters in that state. Should be on the electoral roll of that state. तो ये 1/12 हो गया. And then we have the last 1/12 portion. Okay, so let's look at that also now. The last 1/12 portion so the last 1/12 portion is essentially what we call as teachers constituency. Not the teachers that you drink, but teachers who teach. So teachers constituency. Now what is teachers constituency? Teachers constituency will consist of an electoral college. So here the members are chosen by an electoral college. They are chosen by an electoral college that consists of teachers in the state for at least 3 years. Not below the level of secondary. They may be people, those who may be teachers themselves, who may be elected, some other teachers as well, but voters ये होते हैं. Now here you must understand, firstly what is secondary? Secondary level of schooling क्या होता है? Sorry? What does matriculation mean? Huh? Till 10th. Like what till 10th? Till 1 to 10 is 9th and 10th is secondary. Higher secondary is 11th and 12th. 1 to 8 is primary. First 8 years of education. So teachers, those who are not below the level of 9th class grade, can be a part of electoral college. Exactly who will be vote. See, constitution is only prescribing the base limit. Exactly who will be the voters will be decided as per parliamentary law. हो सकता है कि parliament की law ये बोले that in the state of Uttar Pradesh, the electoral college for this teacher constituency will consist only of college professors, or will consist of only teachers above the class 11th and 12th and college teachers. So exactly who will be allowed to participate will depend upon parliamentary law. Whether, let's say, private school teachers or private university teachers will be allowed, again we don't know. It depends on the parliamentary law. Because see, if you look at 171 clause 3 subclause C, it says that as nearly as may be 1/12 shall be elected by electorates consisting of persons who have been for at least 3 years engaged in teaching in such educational institutions within the state, not lower in standard than that of a secondary school, as may be prescribed by or under any law by the parliament. Exactly who all will participate we can't say, but they must be teachers in that state for at least 3 years, not below the level of secondary. Exact provisions to be determined by the Parliament of India by law. See, Mr. Rajnath Singh came into politics through this route only, teachers constituency. There have been a few other people as well in the past, those who came into politics through this teachers constituency or through the graduate constituency route. Anyway, so this is as far as the structure of the or the composition of the legislative councils in the state is supposed to be. Now here another couple of things are important. Legislative councils, what should be their size? For that, you will have to look at the provisions of Article 171 Clause 1. The total number of the members in the Legislative Council of a state having such a council shall not exceed 1/3 of the total number of the members in the Legislative Assembly of the state, provided that the total number of the members in the Legislative Council of a state in no case should be less than. So, Legislative Councils की अगर हम बात करें, their maximum size is supposed to be 1/3 of the total size of Legislative Assembly. Maximum है वो, and minimum size is supposed to be that of 40 people. Why have we kept this size of legislative councils to a maximum of 1/3 of size of Legislative Assembly? What could be the reason? Sorry? हाँ, तो उससे क्या अचीव होगा? What will you achieve out of keeping the size of Legislative Council at a maximum of 1/3 of the size of the Legislative Assembly? That's what I'm asking. That's all. Yes? Anyone? Because of the that is one logic, because the electoral college 1/3 of the members in the Legislative Assembly, in the Legislative Council are chosen through the Legislative Assembly. So it should be in proportion to that size, and plus more importantly to ensure the dominance of the Legislative Assembly on the Legislative Council. है ना? तो आप ये नहीं चाहते ना कि लेजिस्लेटिव असेंबली से ज्यादा बड़ा साइज हो जाए लेजिस्लेटिव काउंसिल का, या लेजिस्लेटिव काउंसिल में जो चुन के लोग आए हैं वो खुद जो हैं they are more in number than the people, those who are electing them, 1/3 of those who are being elected by the Legislative Assembly. So that is the reason that we have kept this size like this. Now, let's quickly also look at the Legislative Assembly ka composition and structure as well. Then we will talk about the bills that are passed in case of the states having two houses, wo kaise chalta hai. So let's talk about the legislative assemblies in the states now. So legislative assemblies are supposed to be directly elected houses. They used to have a provision for nomination before 2020 for the Anglo-Indian people. One person could be represented from the Anglo-Indian community upon the recommendation of the governor of the state, but that provision has now not been extended. Directly elected houses होते हैं, तो इसका मतलब ये है that every state is divided into, every state's territory is divided into territorial constituency, and these constituencies should be drawn in such a manner so that the population of each and every constituency within the state must have same population. So now if we talk about these territorial constituencies within the state, है ना, अगर हम इन territorial constituencies की बात करें, the number of constituencies in a legislative assembly of a state shall be determined according to 1971 census till the first census after 2026. But the drawing up of the boundaries of the constituencies in the state, which is nothing but essentially delimitation of boundaries, delimitation of constituencies in the state, should be done in such a manner so that size of a constituency in the state shall be as much as possible be same throughout the For that purpose, we use the data of 2001 census. But for deciding the number of seats, we decided on the basis of the 71 census. Also, the maximum size of a legislative assembly can be 500 according to constitution, and minimum size shall be 60. But in some states you will see that the size of the legislative assembly is smaller than 60 also. So that is because of special provisions that have been added for specific states in the constitution. Otherwise, size of a legislative assembly should not be more than 560 as such. But कुछ states के case में 60 से भी कम है because of special provisions that have been included in the constitution. Is that clear? So this is as far as the composition and the structure of the state legislatures in India is concerned. Okay. Now, when we meet in the next class, I will discuss with you what is the procedure for a law to be passed by the legislative council of a legislature of a state that has a legislative council also. And also we will be discussing about the issue of the legislative council's creation and abolition, and do they serve a purpose or not, whether they should be abolished in all the states or whether we should have legislative councils in all the states. That also we will discuss, and we will start with the topic of center-state relations in the next class, starting from the legislative relationship between the union and the states in the next class. Okay. Any questions that you have related to this? Is this clear? Composition of legislative councils, legislative assemblies, their structure, etc. Okay. So please read up a bit before you turn up for the next class related to the legislative relation between union and states, as well as the topic of your legislation in a state legislature having two houses. Okay. I'll see you in the next class.